Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Happy Sunday. Happy Sunday fun day. Today is Sunday, March 2nd, 2025. And I thank you so much for choosing to spend part of your Sunday evening with me. This show is brought to you by popular demand. You guys wanted this. You've been asking for it for a long time. And Andrea's been away for a while, so I had to wait until she got back from her magical mystery tour to come and join me. But once you guys told me that she also was a deadhead, I was like, all right, that's it. And now we're like soul sisters. We've been talking behind the scenes for a long time. And you may know her from actually sitting in the courtroom at the Delphi trial. And for many years before that, she's a OG, one of the OG law tubers. I know that you know who she is. And without further ado, here's my new friend, Andrea Burkhart. Hello.
Hey, Melanie. It's so glad. It's such an honor to be here because you are the OG on this case, on the Karen Reed case. And so I've been watching your channel on this show for on this case for quite a long time. So it's really a pleasure. I'm glad I finally got the chance to meet you and to be here.
Thank you. And we're deadheads and it's like a whole thing. And, and I feel like, somebody said to me once, you and Andrew should do a show where you just talk in Grateful Dead quotes the whole time. And I'm like, I could do that.
Yeah, we totally could.
So because when I put the show up on Instagram today's song is Eyes of the World.
Yeah.
And the audience right here, the chat, wake up to find out that you are the eyes of the world. You are the eyes of the world. The eyes of the world are on this case. And it gives me the chills because this is it's like Judge Cannoni said to Judge Gull, hold my White Claw. I'm coming in. And you can speak to the parallels a lot better than I can because you were sitting outside for a while in a soccer mom chair outside the courthouse until you were so lucky to get line sitters for you in Delphi. How long were you there?
Delphi was, that was like 8 weeks. It was about 2 months that I was there in Indiana. And it was a test of endurance. It was an ultra marathon. We had court on Saturdays too, which was a big part of what made it so challenging is you never had a chance to rest. Because we had the limited, you didn't have cameras in the courtrooms. We had very limited information coming out. And so that's why I kind of took it upon myself to try to be the detail queen. I sat in there and took as many notes as I could about, very specific things because it was one of those cases where I knew that factually, in terms of figuring out what happened and trying to sort the evidence and evaluate is the state making its case here, it really was going to come down to so many of those details. But so then that meant that I had many, many, many pages of notes to come back and report at the conclusion of each trial day. So my streams did sometimes go a little bit long to try to get all that information in. But it was, I thought, an extremely important case to cover, and I think all the more so just seeing obviously the verdict, the decision that was made, the decisions that were made by the court throughout that from my perspective were just absolutely hamstrung the defense, and in many respects just didn't seem to reflect a real considered and thoughtful application of the law. It's just unfortunately the case that certain judges, a lot of the times, they tend to be more focused on the outcome that they're trying to achieve, and they look at how the law and how they can exercise their discretion within the law, the flexibility that they have to really put their thumb on the scale. So I very much saw that in Delphi, and of course, I don't have to tell you, it's a major parallel with what we see here in the Karen Reed case. What, as time goes on, seems harder and harder to deny is just an overwhelming favoritism towards the Commonwealth, a lack of consistent standards being applied to both sides. And that's why I think it's fascinating the posture that we're at right now with this case, where we have these kind of competing sanctions type of issues that are sitting on the court's desk. And it will be quite interesting to see. Do they get the same treatment in this court? Is that going to happen? What do you think?
Like the tossing around of ethical violations, and you notice how Hank Brennan started tossing it out first when he knew what was coming, because he knew that this motion to dismiss based on governmental misconduct was coming down the pike, and so he had to get ahead of it and start throwing hand grenades out there. Defense is you should. I mean, and it wasn't even like the motion that he was arguing was the motion to exclude ARCA. That was not the sanctions motion. That was not like they've been unethical. And no, he just kind of tossed that out there. It wasn't even in his papers. We'll get to all of that. But so many of us were glued to you for hours every night when you were in Delphi, and you took such copious notes, and it made us really feel like we were there. And of course, there's nothing that can make you feel like you're there, when there's no cameras. So kudos to you on doing such an excellent job. And the only thing that could make Judge Cannoni really compete with Gull is if and when she chooses to turn off the cameras in Norfolk County, which, who knows if that's going to be the next Commonwealth motion to come along. But there's a lot of loud people out here. I mean, you even went into Delphi and filed some motions yourself.
Yes, I did. Yeah, I did. I tried to get the access. We had two issues that were extremely problematic from my perspective. The fact that they're audio recording this trial, but just refusing to release that to the public for no real, good reason. Like, why would you not just provide the information and transparency about what is going on in the court process? The other problem that it just grates on me is that the exhibits that were displayed in court, a lot of times, as you know, like in a trial, sometimes they'll publish the exhibit to the entire courtroom. Sometimes they won't. Sometimes they'll just show it to the witness. Sometimes it will go to the jury. So there's a real mishmash as a member of the audience in the courtroom in terms of what you actually get to see as far as the exhibits. So Judge Gohl entered this order that said at the end of each trial day, she would make the exhibits available to the credentialed members of the media. And then Ali Mata, who I think is
hey,
maybe here in the chat.
Hey, Allie's just here.
Ali really soldiered up there and went to go and take a look for herself. There's absolutely no constitutional basis for distinguishing between a member of the media and a member of the public when it comes to access to court proceedings. And so Ali went to look at the exhibits as it was her right to do. She was excluded from being able to do so by Judge Gohl. And so based on that, that was one of the issues that I raised as well with the court, and ultimately trying to take all this up to the Supreme Court in Indiana. And they ultimately did not seem particularly interested in rectifying any of these issues. They got a lot of publicity in the year or so leading up to the Richard Allen trial, because they had changed the court rules to permit the possibility of cameras in the courtroom. And so this was pitched as like, oh, it's a big development for transparency. Look at the court moving forward into the 21st century. Well, the problem, of course, this rule leaves it entirely in the discretion of the trial judge. And so Judge Gohl says, no, I'm just not going to. And there's no recourse for that. But what they also didn't mention is that in the background, they were also modifying the court rules to ratchet back on things like the public's ability to access things like the audio recordings of the trial, which previously under the old rules, these were considered a court record. It would have been something that was subject to public disclosure. Under the new rules, they specifically exempt that. So only the parties now can get the recordings of the court hearings. So it's just this very underhanded and politicized type of process, which is just unfortunate because, number one, that's exactly how the court is not supposed to act. The court is not supposed to be politicized. That's how you delegitimize your process. But two, just again, because the transparency, I am such an advocate for transparency in the courts because the courts are ours. That is where we, the people, are directly involved in the justice process. We elect the people who go into that courtroom, who prosecute cases. They do so in our name, on our behalf, as representatives of the people. We sit on those juries. We are entrusted with making those decisions. And so it's critical for us to be able to observe that and to know, is this system functioning the way that it's supposed to? If these rules are not good rules, then we need to elect different judges. And so it's all part of our participatory government, that we have access to the courtrooms and that we're able to see and know what is going on inside and to be able to monitor that. So the way that the Indiana court here was really just making this show as though they're facilitating this type of access, while in reality they are taking it away behind the scenes, was just so incredibly offensive to me. So pardon my rant.
I mean, look, you're as passionate about procedure and the Constitution, I think, as I am, because I get crazy about it too. And it's like, it's interesting that you say elected, because in Massachusetts, the judges are appointed, so, totally different scenario. Like, they're appointed, and that's, another problem. But did she have any rationale for saying no cameras? Did she just scribble on the bottom of a piece of paper, denied?
Judge Gohl never had rationale for any of her decisions. Never. She would just deny without a hearing and provide no explanation. So no explanation for no cameras. Just no, there won't be any.
Well, we're getting to that territory. For anybody who's here, I pretty much think everyone here knows you, but just tell everyone who may not know you a little bit about your background, and whatever else you want to tell everyone.
Well, so I've been a practicing criminal defense attorney in Washington State for almost 20 years now. God, I'm getting very close. And most of my practice today is in appellate work, but I have been a trial attorney as well. I've done a whole variety of different things in my career because I had the luck, I guess, to be a small town retail lawyer where it's kind of just the old country lawyer model where you do what needs to be done for the client that walks through the door. So I got to be involved in estate planning and transactions in real estate and land use in all kinds of different issues that I got to have some experience with. But the bulk of my practice has always been focused on criminal defense, and primarily as a public defender. In Eastern Washington, most of our public defense offices are contract. We don't have like a central office. You just, as a private attorney, you contract with the county to be a public defender. And so that's what I did for almost close to 20 years of my career. So since 2018, I've been exclusively practicing at the appellate level. Don't do trials now. Maybe I'll go back sometime, but it's just
but
not.
so you've got you can help us with all sides of this, with the defense side, with the trial practice side, and with the appellate side.
Well, that's my goal.
Where'd you go to law school?
I went to law school, Thomas Jefferson School of Law in San Diego.
Oh, nice. And then you went back to Washington. Did you grow up in
And then
Washington?
I did. I actually live in the town I grew up in.
Oh, that's nice. That's
Yeah.
nice. I went to Denver for law school,
Oh.
and then I went back to New York. Actually, I was in Boulder undergrad, and then I wanted to stay out there. So I'm like, all right, what could I do? Oh, I know,
Yeah.
I'll apply to law school. So it gave me an extra 3 years in the mountains. And every day that I came back to New York, I'm like, why did I come back? But I love SoCal. Like, if I could move right now, I would move to Southern California.
Yeah.
Again.
It's wonderful, but it was a challenge in terms of being a young lawyer coming out of law school, especially in that time frame. There were several law schools in San Diego. Very, very difficult to get a job. Very competitive. It's an extremely expensive area to live. I would have enjoyed it. I think my heart was in Northern California. I spent 3 years in Lake Tahoe before I went to law school.
Oh, nice.
Like kind of my gap year that turned into 3 between college and law school. So everything else, if I had had the opportunity, that's what I would have liked to have done. But life took me in a different direction, and I can't say I regret where I am.
Well, you might like this story then. A long time ago, because I have at least a decade on you as far as like legal experience goes and life. I saw Jerry Garcia play in Lake Tahoe in a casino. It was Jerry Band, and the ladies that would sing with him.
Oh,
and
yeah.
I played blackjack with those ladies. Like, they were running the tables all night. And it was like this little tiny theater. It was like a dinner theater. Like, we had a booth, like a half round booth, and we had waitresses, and there was Jerry and his ladies up there. And it was like, those were the days.
That's awesome.
Those were the
That's
days.
awesome.
It was like hitting the reset button of life,
Yeah.
Might as well, right? Might as well travel the elegant way, which, by the way, that reminds me that you just had a really nice 2-month trip. For those of you who follow Andrea on Instagram, got to see some really gorgeous photographs of your trip.
I did. I was so lucky to have the chance to be able to do that. I was down in Chile, which is becoming my home away from home. I love it down there. It's amazing. I recommend it to anybody who likes the outdoors. It's hard to describe how fantastic it is. One of the things I love about living in the West, in the United States, is that we don't have a whole lot of mosquitoes. We don't have a lot of bugs compared to trying to hike in Florida or North Carolina or something.
Oh yeah,
like
the bugs are like the size of hummingbirds in the Outer Banks.
A little bit of a different environment. So we have a much better system out here in the West as far as that goes. But it's nothing compared to South America. It's amazing to me. A lot of the places where I was spending time are Valdivian rainforest. So it's a temperate rainforest. It's very damp. It's very lush. It is like a jungle. And there's still no bugs. It's wild. It's crazy. I'm like, if you were, it reminds me a little bit of the Olympic Peninsula over here in Washington. For anybody who's, from this area or familiar with that area, just climate wise. And, Olympic Peninsula, Olympia, you can't sit out on your front porch, after like 6 p.m. without, a lot of bug spray and stuff like that. It would be bad. But South America, it's not like that at all. It's just incredible. It's a wonderful place to be able to enjoy the outdoors. And obviously the scenery is it's unparalleled.
Yeah, your pictures were phenomenally gorgeous. So gorgeous.
Oh, thank you.
We missed you, so I'm glad you're back. I looked it up, and it seems that the Delphi verdict was on 11/11.
Mm-hmm.
And so we haven't seen much of you since then. So you are going to run the show. Tell us what you want to talk about Karen Reed, because I have been here screaming since you were gone. And it continues to outrage me more and more and more. Just when you think there can't be any more duckery than there already is. We call it duckery because of Richard Schiffer, who was arrested on all those felony charges of putting those little ducks around town with the little Colin Did It stickers on the bottom, but for which, by the way. The Massachusetts State Police did a 36-page police report, which is
Mhm.
a way longer police report than they did for the
Mhm.
murder of a Boston police officer, which should shock
Mhm.
anybody out there.
Mhm. Yeah.
Tell me what you want, where you want to go first on this.
I mean, God, it's crazy how much is going on with this case right now. I was trying to explain. I was telling Jeff when I got back. Jeff's my husband. He's also my main mod on my channel. So I was kind of trying to clue him in on like what's coming up in this case, because I'm like, oh my Lord, there's hearings this week on the motion to dismiss, or at least they're supposed to be, because the defense is, asked to continue that, and we will see what happens, I guess. I'm not
Brennan
expecting.
is opposing this. Did you see Brennan
Yes.
is opposing the continuance,
Yeah,
even though
I
he's
did.
not going
I
to turn
did.
over more video until tomorrow?
Yeah. And I'm sure that what Judge Canoni is going to do is something along the lines of, well, we're just going to get through what we need to get through. And if, you're going to, if you have to come back, then tell me, or something like that. But she's not going to like stop the hearing this week. That's my prediction anyway. So we've got that coming up. The federal habeas petition is being heard this week. The deadline to file motions in limine is this week. The final pretrial conference is this week. The hearing on the motions in limine is in 2 weeks. And then we're supposed to have trials starting April the 1st. And my mind is blown. Like how is all of this going to get done? How is all of this going to get done? Is this realistic? Is this feasible?
Is this real life? Are we in the real world?
Should it be that way? Should we be rushing headlong to get the trial started on April 1st, come hell or high water? Do we need to be taking more time to sort some of this stuff out? I don't know.
I think we do. I mean, I think that, we were waiting on the SJC decision, which did come in finally. And now that they've moved this, or they've filed a new petition in federal court, maybe we'll start there, because that's probably chronologically the first kind of thing that has happened lately. So they lost the appeal. What a long, strange trip it's been, is right. They lost the appeal at the highest court of Massachusetts. And so they filed a petition in federal court. Maybe you can speak to that a little bit and your thoughts on that, the double jeopardy issue.
Yeah, so this is kind of wild. I mean, so I don't practice in federal court, but I have to advise my clients about habeas processes. I have to kind of handle my appeals with the habeas process in mind, just because it's an extremely technical area of the law. And a lot of pitfalls and things like that. So I certainly have some familiarity with habeas, although it's not an area that I personally practice in. But that said, extremely unusual to see a habeas petition while a trial is still going on. And obviously there's pretty significant implications in terms of, if the trial goes forward and the court hasn't decided the issue, it moots it. And so that potentially creates a little bit of concern for me in terms of what the incentives are for the court in terms of how they're going to handle this process. Now, what I mean by this is that when an issue becomes moot, it basically means that for whatever reason, the court can no longer give effective relief. And so it typically means because there have been new developments that kind of undermine the justification for what you're asking for in the first place. And so the problem here is that the defense, Karen Reed's defense, is arguing this is a double jeopardy problem. She was acquitted on these 2 counts. The jurors unanimously agree about that. Judge Canoni rushed forward to declare the mistrial without looking into alternatives, without inviting any kind of input from the defense about what they wanted to do with it, and so forth. And specifically without asking the jury, is that about everything? Can you return a verdict on any of the counts, or are you deadlocked on all of them? So subsequently, of course, learn from jurors who came forward of their own accord. They were not sought out by anybody, but they specifically themselves came forward initially to the defense and then also to the Commonwealth as well to say, no, we unanimously agreed she's not guilty on counts 1 and on counts 3. So that's a potential double jeopardy problem, right? You can't be tried for a charge that you've been acquitted on. But the problem is, so the recourse that she's asking for in the federal court is basically throw these charges out. Don't retry me on these charges. Well, the problem is if it takes the court too long to make the decision, she's going to be retried on the charges. And so then at that point, the trial is over. The court can't go back and say, don't retry her. She's already incurred the harm that her petition was supposed to alleviate. So that's a concern I have just procedurally about kind of an option procedurally that's available to the federal court that allows it to kind of wash its hands of the issue, not have to really make a decision about it, not have to engage with it. All they have to do is wait, and the problem goes away. And this is a particularly touchy issue for me because that's kind of what happened with at least part of my petition to the Supreme Court in Indiana, the one that dealt with the press getting this, privileged access to be able to view the exhibits, while we, the public, were excluded from being able to do that. And the Supreme Court sat on my petition until the trial was over. So now there's nothing, they can't change and undo what's already happened. So basically just let that issue go moot. Now, they didn't say specifically in their decision because they just summarily denied it. They didn't give me any reasoning either, any more than Judge Gold gave reasons for anything. But that was certainly, a basis that had they, written out a formal opinion about why they were going to deny it, that could have been invoked. There's nothing else that they could do at that point to fix that problem. So we've seen.
So question for you, Judge Cannoni, the federal court cannot order Judge Cannoni to stay the trial until they've had an opportunity to hear the case. Because there's a hearing on Wednesday, but it's a little unclear about whether they're going to argue the appeal on Wednesday or whether this is a conference of some kind. So I don't really know what's going to happen on Wednesday. I don't know if you do, but
yeah, it's a good question.
To stay the trial?
I think I had assumed that it was the argument on the motion, just because the judge had he had entered the order for, kind of accelerating the schedule for it in light of the fact that the trial is upcoming and stuff. So that was a bit promising, at least to the extent it suggested that he does want to actually decide this and get something done on the merits before the trial goes forward. But of course, that's not binding. He's a judge. He gets to do whatever he wants. Now, can he stay the trial? Boy, that's a great question. And honestly, I'm not sure. Because you have this jurisdictional issue always when you have a federal court versus a state court. And what's the scope of their authority? I don't know if that would encompass a stay of the trial court. I guess it might. Do you have any insight into that?
Somebody here is saying federal courts won't touch it before a verdict. She has shown, based on her prior history, that she doesn't really think that she's subject to federal orders, because I remember, I think it was pretrial, and there was a federal order to seal some things, and she was just like, well, I'm not bound by that. And I clearly remember that. I don't remember exactly what the issue was, but she seemed to poo-poo the federal order. No big whoop, not for me. So I was assuming that it would stay the trial and that she would have to postpone it and wait for that decision, because it's such a core constitutional issue. But
yeah,
I'm not absolutely sure of the answer. Didn't Kurt say the federal court won't take this? Kurt said that he says they don't have to take it. They can decide whether or not they want to take it. Because Kurt was here the other night and we talked about it, or day. I don't remember. I don't even know what day it is anymore. So that is just, one of the issues is the double jeopardy. And now you throw into the mix the whole possibility of jury tampering, which is reminiscent of Murdoch. It's like, how many cases can we throw into the Karen Reed case? It's like the smorgasbord of every horrible case that has been around for the past couple of years. So,
Well, and part of what's really, really alarming about that one as well is obviously so much of that motion is redacted. The response is redacted. We don't really get to know the factual details of what exactly is being alleged as far as jury tampering. So we have to read between the lines based on what they're briefing and the cases that they're citing and why they are presenting this case law. And that has got some details in it that are really, really troubling. The suggestion in particular that a juror was removed based on the juror's views and not based on, some type of personal conflict that the juror had. That's extremely troubling to me because it puts you in a situation where just having a new trial is not an adequate remedy. If you have somebody they're entitled to an impartial jury, they're entitled to the jury that they picked when they went through voir dire to be able to decide the case, follow it through to the finish. And then if you have a court that just decides we're going to selectively remove jurors who are favoring one outcome or the other, it's not a remedy to give you to just give you a new trial, to just act like that didn't occur,
right,
and keep pushing you in front of a jury until one of them, ultimately finally decides to convict you. That's not right. So there has to be some other recourse or some other remedy if that type of misconduct is in fact what's at issue here.
it seems like, I mean, so much of it was redacted, but the first issue is that allegedly this trooper Fanning was in charge of the jury. Fanning.
Thanks, Commonwealth, for letting us know that.
Yeah. Al Jackson said he didn't find out until 10 minutes before his closing.
Yeah.
For those of you who don't know, Fanning was Proctor's supervisor. Fanning, although I don't think he was on either witness list, he was on the chain of text messages with Proctor when he was looking for nudes, when he was talking about, strong arming the medical examiner into changing the manner of death on the death certificate. And he was also the lead investigator in the Sandra Birchmore case. And for those of you who don't know, Sandra Birchmore met a Stoughton cop named Matthew Farwell when she was 11, 12, 13. She was part of the Police Explorers program. He took her virginity when she was 15. She wound up pregnant with his baby at 23. He was married. She was found dead in her apartment in Canton. He was still a Stoughton police officer. His wife was, in fact, actually in labor at the time of her death. And Fanning, who was in charge of that investigation, very quickly ruled that a suicide. So he's got a history, let's say, of covering up for cops who commit murders. Maybe. I mean, hypothetically, right? Because so many of the same players were involved with the Birchmore investigation as the John O'Keefe death investigation. Trooper Garino missed over 30,000 text messages on Matthew Farwell's phone. He's also the guy who missed Jennifer McCabe's deleted Google search at 2:27 a.m. So there's a lot of parallels there. And if anybody out there, I don't care what side you're on, if you're on the Karen Reed is guilty, we're going to hang her in town square before we stone her to death side, you cannot think that in any world that this is not a conflict of interest to have Fanning anywhere near that jury. Brennan came out. Did you see his opposition papers?
Yeah, I did.
In his opposition papers, he basically said Fanning never saw the jury. Fanning never went inside the courthouse. Fanning was outside doing crowd control, some other BS, and made all of these statements of fact, but did not attach an affidavit from Fanning.
Yeah.
In what world is that acceptable?
In Judge Canoni's land, it was the same thing in Delphi. It was the same thing that we would run into Delphi. You would have unsworn attestations from the prosecuting attorney, and they would be accepted as true because, that's the lack of the even playing field. The defense is not going to be able to do that. When the defense tries to do that, they're going to be, chastised for it, or they're going to be accused of being unethical for it.
Right.
But let the Commonwealth do it. And there, suddenly doesn't seem to be a problem. And not to divert you from the point that you're making, which is good and important, but it's it's one of the mind-blowing things about where we're at right now. The relative wrongdoing that is on her desk with respect to, on the one hand, you have Alan Jackson alleged to have, maybe because of the context in which the whole argument about ARCA and their role and their preparation of their opinion, their whole accident reconstruction analysis and so forth, being independent, whereas, perhaps the allegation, as best I can tell, he may have not been quite careful enough in how he expressed the relationship with ARCA, because there was subsequent, after the trial, payment by the defense, because ARCA had to come to Massachusetts and testify on 2 separate occasions and 2 separate hearings. They didn't do this for the federal government. They didn't do it as part of a federal investigation. They did it pursuant to a defense subpoena, but they did it apparently without any type of contract, any type of prior understanding, because that was specifically off limits from the federal government for them to be able to have that type of coordination. Nevertheless, the defense thoroughly disclosed all of this to the Commonwealth before they were even required to do that. The certificate of compliance, being when it was filed, like the defense didn't even have to turn this stuff over yet, but they did. And so, did Alan Jackson maybe, could have worded things better in his motion or in his sidebar or something like that, and spelled all of that out in greater detail? Well, it wasn't relevant at all to the point that was being made in those particular motions. But that's essentially the argument. That's the wrongdoing that's being alleged against Alan Jackson. And it was so outrageous that, Judge Bev is,
she was literally like shaking.
Yes.
Yes, I thought she was going to have a stroke.
Grave concern, and this could seriously affect the defense and so forth. And so much that we have to, come back and have a special hearing on it.
And a lie unchecked becomes the truth. So the fact that hung out there for a week, when Brennan got up there and absolutely 100% lied to the court when he said, we had to get all of this from the feds. And he can't say that he was mistaken, because there was an entire monologue leading up to it that was building up to this whole thing. And then after she takes her time out for half an hour and comes back shaken, like the grave implication, he's like, oh, I'd like to just, straighten out some chronology, right? Chronology. He did not say, I need to correct the record, Your Honor. I'm sorry. I need to correct the record. It wasn't the defense the feds the defense actually gave us. Correct the record. Chronology. And he buries the lead in there somewhere, and the media runs with it for an entire week. If you think that's not prejudicial, jury summonses have already gone out at this point. So people are already getting letters in the mail. That was outrageous.
Yeah.
And you want to talk about ethics? She hung her entire hat on, this is what I think, because I've watched this several times. There was a sidebar. We didn't get to see it, obviously, but because when she first came out that day, she said, I am very concerned about, the sidebar that we had. And Mr. Jackson, you said that ARCA was not hired by you, and so you didn't have anything else to give them, right? And when I'm thinking about this, I'm thinking of materials, right? They want all the materials that were reviewed by ARCA to make their opinion.
Because that's the motion. That's what the motion is about ARCA's materials.
Right. We did not hire them. And he's right. They did not hire them. They never hired them. They called them as witnesses at trial, and they paid them after the fact when the bill was drop mailed to them, and they called the feds and said, are we allowed to pay this? And they're like, yeah, pay it. That's a lot different than hiring an expert. I, as a civil litigator for 30 years, hire experts all the time. Several times a week, I'd be dealing with experts, accident reconstructionists, doctors, and I did civil litigation. So in civil litigation, we deal with experts much more than in criminal litigation. And that's why they brought Bob Alessi on, in my opinion, because he's a civil litigator. His forte is experts. This is what he does all day long. And so, first of all, you never hire an expert. They always want an upfront retainer. So the fact that they didn't pay them an upfront retainer tells you they didn't hire them. They didn't hire them to do the work. They didn't give them any of the materials. And even in the voir dire of the ARCA experts, which was, by the way, I went back and watched it. It was maybe like 45 minutes for each one of them, Dr. Wolf and Dr. Rentschler, including Cross. Dr. Wolf said, here's the things that we reviewed. And he gave a list in his report of like, I forget how many, 14 things. And Lally went through them all. You review this, you review that. So they know what they reviewed. And I'm going to assume the defense and the prosecution both have all of those materials. So to get up there and, start screaming about, you don't have these materials, they won't turn them over, rings a little bit hollow to me. Because they knew what they reviewed from the voir dire. And they have it. I'm still thinking, like, what's the big deal? What's the big deal? Why are we talking about pulling his pro hoc status? Why are we talking about removing her right to the counsel of her choice? When
I saw that motion initially, my initial reaction was, the defense, they should just get the copy of the trial testimony, the trial transcript for those two witnesses, and hand it to the Commonwealth and say, there you go. That's what we anticipate they're going to testify to. Exactly the same thing that they testified to before.
And Lally had the opportunity to voir dire them fully and ask them anything. Nothing was off the record. Have you ever spoken to Mr. Jackson before today? Have you ever emailed with Mr. Jackson before today? A simple email saying we'd like to retain you, and then an email back saying you can't because the Fed said pause. I mean, work product. I don't know what the hell's going on in Massachusetts, but apparently they also have to hand over their impeachment material, because that's another part of this motion that I have a major problem with. It's like, here's my smoking gun so that you can prep your witnesses with my smoking gun, so you can therefore take away my smoking gun. Like, that's a world that I'm not familiar with. Does that happen in the state in which you practice law?
No. No.
If you were going
your
to
discovery
impeach,
obligation is for what you are presenting in your case in chief, and as far as what you need to hand over for impeachment or for rebuttal or something like that, before the witness testifies,
you're allowed to impeach them and put them on. Isn't that the whole point? Is that you're surprising them?
Yeah, exactly.
And it was interesting to me to go back and watch that voir dire, because remember, the recent voir dire on Dr. Russell was 2 entire days. And the voir dire on both ARCA experts was literally like an hour, maybe at the max. And she said, oh, I wish I would have known it was going to be this short. I would have, because it was only a half a day of court that day, because she put aside the whole day. So listen, just because Lally dropped the ball doesn't mean you get another bite at the apple. It doesn't mean that you have the right to get up there in open court in front of a worldwide audience and accuse Alan Jackson of some major ethical violations when you're absolutely standing up there lying to the court yourself.
But so then the judge took that and ran with it, and she allowed that outrage to show. She allowed that to be part of the story. She allowed that to drive her actions, as far as, this is so bad, we've got to give you notice, and you got to come back next week. And then that leads, like you're saying, to all these this whole media cycle where it's like, oh, they're going to have to show up with criminal defense attorneys and like it's clearly planting this seed of this, egregious wrongdoing on the part of the defense. Now we have to, in fairness, hold that up next to the defense's motion and what the Commonwealth did to our freaking faces in that first trial, lying to our freaking faces about that video. And
Sergeant Buchanan, is this a fair and accurate representation of the way the Sallyport looked on January 29th, 2022? Yes.
Nobody near the right rear taillight. Nobody near it. Look, you can see for yourself. Nobody in that area. Yeah, they absolutely lied, and I couldn't help but notice that in Brennan's response, to that motion. Oh, he, undermine. He's trying to, of course, throw back on the defense. It's we were never dishonest. In fact, we played the whole video after it had been, after the defense had gone and flipped it the right way.
The defense altered it.
He never once addressed that testimony. He never once addressed Trooper Buchanan's testimony about how nobody was ever near the right rear tail light, because you can't get out of that. That's what shows their intent to mislead and their intent to deceive. And the fact that they did that, the fact that Lally let him get away with that, didn't correct that. That's a Napui problem. We've had Napui going on over in Coburger land. So that's kind of like, and in Richard Allen as well. So this is kind of like on our radar right now. Prosecutor not correcting false testimony is a big freaking deal. There was just a U.S. Supreme Court decision that came down in the last couple of weeks about this, the Glossop decision, where a death penalty conviction gets reversed because the prosecutor puts his snitch on the stand who testifies falsely. The prosecutor knows that it's false and he doesn't correct any of it. Major due process problem for a prosecutor to behave like that. So they did this to our faces. They don't even have an answer for it in their own opposition. And how do you think these are going to be treated in Judge Cannoni's courtroom? Do you think they're even going to be equivalent? Or do you think she's going to find ways to just explain away why the Commonwealth did what they did and why that was just a misunderstanding or bad communication? Whereas Mr. Jackson,
Right. It's a privilege to practice in Massachusetts, Mr. Jackson.
mm,
Well, also in his opposition, he says, we have video from January 1st of 2022 that shows that the camera always taped inverted videos. Well, I'm sorry, what? Now you're coming up with video from January 1st when you said everything was overwritten in 30 days and you're still giving us videos as of like January 28th. And now you're even going to give us more video tomorrow?
Yeah. Yeah, this video is it's got to be some of the unraveling. And I'm so glad that this is happening, honestly, because back during that first trial, when we got the mistrial, we knew we're going to, potentially be doing this all over again. That was my perspective, is you absolutely have to focus in on this inverted video. You've got to laser focus on that because, look for the metadata, look for the comparisons, look for video of other ghost people with weird skipping times and people materializing here and there. And is that one angle from the Sallyport? Is it always dark like that? Go through, and really nail down those details, who had access to it, chain of custody. And so I'm so glad to see that they're doing all of that because, I think this is where it's going to start to unravel, and we're starting to see it unravel. I spend way more time on X than I should. It's such a cesspool.
I don't go there.
But there's just
good. You can tell me what I'm missing.
You did the smart thing by getting out of there, but I can't help it. There's just a lot of good information that goes around and comes up and gets shared, and it's like a good just a group mind, that's able to kind of collectively source things and bring a lot of different expertise to these different problems. But so a lot of X over the past, I'd say week or so, has been really picking apart at some of these problems. Yeah. The fact that you can go in and screenshot. There was a moment from the first trial when Lally had on the screen his file folder for these different Sallyport videos, and the metadata is showing June 2023, last modified date. Now they're trying to say they didn't even know that these videos existed until sometime late in 2024.
Yep.
Trooper Proctor is up on the stand saying he doesn't really remember when he first learned about the Sallyport video, but he thinks it was just maybe a couple weeks before trial or something like that. Apparently he's asked about this in his grand jury testimony. Like, this is what's going to reveal, I think, the corruption that we've all known has been there, that has been in front of our faces. It's been flagrant for so long, and they've just assumed that they're going to be able to wiggle around, to make excuses, to come up with explanations, and always be able to talk their way out of it. I think they might finally, with this inverted video, be stuck in a corner that they can't get out of. I think this has the potential to be the knockout shot. And that's why you see Lally, or you see Brennan. You see him fighting the way he's doing, the way he tried to dirty up the defense, like you pointed out. Let's try to create a distraction. Let's try to create an opening. There is, we haven't talked about my boxing, but I box.
Yeah, you're a boxer.
And, there is no time when the opponent is more dangerous than when they're hurt, when they're seriously hurt and they know they're about to go out. That's when they are extremely dangerous because they got nothing else to lose now.
Bob Dylan said it best, right? When you ain't got nothing, you got nothing to lose.
You got nothing to lose. And so I think that explains so much about what we're seeing with the strategy, why he's trying so hard to turn this on to the defense. He's trying so hard to say, look away. He can't even deal with the core problem here, which was that false testimony from Trooper Buchanan that Mr. Lally never bothered to correct. So he's got to just overlook that and pretend that that's not there. This is a string unraveling, and I just want to see this continue to be pulled.
But is she going to have the balls to do anything about it? Bob is here. Bob from Defense Diaries here, and he says, and why, if the Commonwealth knew about the alleged camera issue, did they not mention this when challenged during the trial? Right. And they also said the cameras have since been replaced, which is so interesting because when their expert went there in December to investigate or to look at the DVR system or whatever they're calling it, nobody said, oh, the cameras have been replaced. Like, this is all new information.
Yeah.
And then, because I have the motion pulled up over here, for him to make the argument, and this is what he says. I'm going to read it verbatim because it's just, I laughed while I was reading this to the audience the other day. I was laughing throughout. I could not contain my laughter. While the January 28th, 2025 production of video was untimely, the poor quality of the video makes it difficult for either party to benefit from. Furthermore, this video depicts the same event that was contained on the surveillance videos produced on April 4th, 2024 and April 23rd, 2024, simply just from a different camera angle. She's backing into the Sallyport in this video. And then he says, further, while the Commonwealth would argue that the videos from the Canton PD station Sallyport are inculpatory, the defendant benefited during the first trial by suggesting without any substantive evidence that the poor quality of the video and or gaps in time due to an improperly functioning camera system were caused by an improper police investigation and systemic police misconduct. So she benefited from the poor quality. In good faith, as an officer of the court, could you even have the balls to make this argument? Yeah. She was lucky that we gave her such piss poor quality video. It benefited her. In what world are we living?
Well, we're living in a world where this has been the gaslighting trial of the century. It really has so much gaslighting throughout this entire trial. Buchanan in particular was extremely good at it. I hope they are better prepared for his recitation of the drinks in the bar, because when we watched that live on my channel, we watched that video very closely while he was saying, and there she is taking a drink, and we can see with our own freaking eyes that there is nothing at all like what he's describing that the rest of us are able to see. So it's just kind of par for the course with how this trial went. But they're expecting us to overlook the fact that despite multiple opportunities, despite having every incentive to document the state of Karen's SUV from the very first point when they had contact with it in Dighton, why on earth would you not document it? Why would you not document it as soon as it gets back to Canton? I mean,
why wouldn't you document it when you're in the ducking driveway? Why wouldn't you whip out your state issued cell phone and snap a picture of the taillight right then and there? Why wouldn't you do that? Because there's too much snow on the ground and you didn't want to get your boots wet. Like, I saw, again, somebody sent me this because I'm not on Twitter, but they sent it to me that somebody's out there making the argument that they're showing the car pulling in, and it's like the snow is up like past the tires, and they're like, "Do you really expect them to take pictures in these conditions?"
Oh yeah, I saw that.
Like, no, no, no. In fact, I don't even expect them to even look for evidence in conditions like that.
Yeah, no, didn't you know that when it snows out, then that's when the solo cup rule is invoked, you see, and all evidence collection operates under entirely different parameters than it does when there's no snow. The whole thing is absurd, and it's the reason it's gaslighting is because they are expecting us to just accept their version of events because that's what they say it is. They say so, therefore that's reality, and so they say Karen's taillight was shattered at the scene, and that's where they found all of those 47 pieces or whatever it was that they were then able to meticulously piece back together, except peculiarly enough, that one little section from that taillight that remained missing, that's kind of, looks right about when you have that photo from the 830 dash cam that shows, it looks like maybe on that side there is a little bit of a defect. Yeah, right there in that area where that little small piece would be missing. We're just supposed to take all of this on faith because they say, and then all of the missteps, all of the mishandling, all of the opportunities that they had to do things the right way that they didn't bother to do when they're investigating a dead freaking police officer. And
Right.
of all times for you to just decide the rules don't apply, we're supposed to believe that all of these assumptions for why you chose not to do that are just innocent and just go in your favor, and none of that benefits Karen Read. Why? Just because you say so. And
Ipsy Dixit has become
any reason for us to have good faith in they say so, particularly when they get up on the stand and they lie to our faces about the video and what the video is showing us.
Ipsy Dixit has become my new favorite Latin phrase because he said so. Because he said so. Ipsy Dixit. Ipsy Dixit. It's like everything in this case is just, and it starts to make you feel like you're going insane. And and that's what a good gaslighter can do, is make you question your own reality and your own, like, am I going insane? Like, does this really happen in other jurisdictions? I mean, is this really allowed to go on out there in the world where people are supposed to be, innocent until proven guilty? Isn't that what our Constitution is based on? And isn't every defendant supposed to have a fair trial? And aren't we supposed to exclude evidence that doesn't have a proper foundation or can't be authenticated? Isn't that the way it works in the real world? Well, then we're like, well, maybe it doesn't. Maybe we're nuts. But when lawyers with decades of experience are all coming together to say, this is insanity,
it stinks.
There's
Stinks.
no metadata, and
you don't need a magic nose to smell the stench of this case.
And you don't need a degree in biomechanical engineering or a medical degree to know that the injuries sustained by John O'Keefe did not come from a car. They didn't come from a car. That's how I got involved in this case.
That's how I got interested in it. That's how I got interested in it. It doesn't, none of it passes the eye test. And the kind of turning point for me, I came into the trial knowing very, very little about the evidence. I had seen the autopsy photos. Somebody had sent me that. And I just kind of knew the general outline of the allegations, and that was it. So I was, open for the Commonwealth to show me that John O'Keefe was hit by a car. That's critical. That's the critical fact. Step number one. If you can prove that to me, then it's going to be a much shorter step to proving that it was Karen Read's car, just because of the whole circumstances and everything. But so just prove to me that he was hit by a car. And the turning point for me was the day when they were showing his clothing where he's got blood stains right down the front of his shirt, and like his pants, like a million times has happened to me in the ring, because you get a bloody nose when you get popped, and it drips right down your front and down your pants and onto the top of your shoes. Exactly. like it dripped on John O'Keefe's clothing, and exactly like it would not drip on his clothing if he'd been hit by a car and collapses on the ground and lies in the same position for hours on end until he dies of hypothermia.
Well, they want to call the weatherman.
It can't be explained.
They want to call the weatherman now to say that the ground was really hard. The ground was really hard. And he wants to come in and testify the hardness of the ground and that's what cracked his skull. And also, I mean, possibly from a head injury, it could also cause you to vomit, right? There was vomit found in his boxers, in the front of his boxers.
Mm-hmm.
I just want to thank Tracy Walker real quick because she gifted 20 and then 50 memberships. Tracy, wow. You're amazingly generous and so sweet. And thank you so very much. And to the 70 new members, welcome. I think you're going to like it here. So now the metadata,
Mm-hmm.
they don't want to have to turn over the metadata. They don't want to and the judge said, it's okay. You don't have to turn over the metadata. As a defense attorney, talk to us about, especially now, with the advent of AI and such things as like CapCut and, being able to just make up videos. And Microdots has a great video that also is on Twitter of like them washing the car in the Sallyport. And Richie is amazing. If you're here, shout out to Microdots. Go follow them on every social media. Made like an AI video of them washing Karen's car inside the Sallyport. And it's totally fake, but you can't tell. I mean, it looks amazing.
Yeah.
Why is metadata important, and why should a judge not allow any evidence that doesn't have metadata as evidence in this trial?
It's critical to authenticating the evidence, right? I mean, you know that, I know that, because what do you have without it? You have Ipsy Dixit. You just have, trust me, bro. And they have shown us consistently over and over and over again that they aren't to be trusted, even if we just limited that to this specific video. They are not to be trusted with respect to this specific video. They can't tell us a consistent story repeatedly over time. It has to keep changing when they're able to get it, what they're able to access, what format it's in. Is there a chain of custody or not? We're apparently now getting a chain of custody.
Well, the retired detective missed his tea time yesterday because he's at home creating this chain of custody log now, which, as you know, needs to be contemporaneous with the event. So it should be just use as toilet paper anyway. But they said they don't have it. And you can't expect us to manufacture evidence that doesn't exist. And then the judge said, Ms. Little, you can't expect them to manufacture evidence that doesn't exist. Is that what you want them to do? And she said, well, no, Your Honor. And now they're manufacturing evidence that didn't exist but they don't know when they're going to get it because the retired detective is really busy because, he's retired.
Because he's retired. Well, beach houses take a lot of work. Apparently, this whole law enforcement retirement system in Massachusetts, boy, is that a gig! How impressive is that? That little game that gets played.
It's great. Yeah. So let them retire before they're terminated, so they get to keep their pension. Works out well for them, right? Or. R.I.P. Ken Berkowitz, who sadly and tragically has passed away recently. And my opinion, as is many of the other people who are out there on the cesspool of Twitter, even though I'm not, think that perhaps they're going to start pointing the finger at Chief Berkowitz, who is now 6 feet under. And, are they going to pull that one out of the hat next?
Great question. I mean, he's a good target for him, right? Can't put a finger back.
Yeah. I mean, a lot of people thought they were going to start pointing the finger at Higgins because, he's not in the fam for real. But now, now they've got a different, look, they pinned it on the girl. First, they wanted to pin it on the girl, blame it on the dead guy, right? The guy never went in the house, blame it on the dead guy.
Yeah.
How does it go from being on a retired detective's iCloud to then being on the retired detective's hard drive? And now it was like, now it's in a paper file?
Paper file somewhere?
It's like magically delicious. Like how can you keep morphing your argument with a straight face? It's very Baldwin-esque to me. We took in this evidence, we put it in a different file with a whole different file number.
Yes.
And I didn't think it was relevant, so I didn't turn it over because even though I'm a prosecutor, no big whoop. I'm going to make the determination on what's discoverable and what's not, and what's evidentiary and what's not, and whether it's relevant. And so then I'll put myself on the stand, make a laughingstock out of myself, and ruin my whole career.
Oh, what a disaster.
Except in that case, the judge was like, that's it. Case dismissed. Everyone, Mr. Baldwin, you're free to go.
Yeah.
And him and Ilaria got to have their hug, and they got out of there. It's like oopsie Dixit. Yeah, somebody said I saw that goodbye. But metadata is not important. It's not a thing. And now the chain of custody logs are going to magically reveal themselves, just like the evidence magically revealed itself.
Well, and
the taillight
that's
pieces.
telling too. It's telling too. It's telling that this is how we know how bad they are backed into the corner, is the fact that they are now having to come up with the chain of custody log. And the reason why is because they can't get out of naming names now. Who was involved? Even in Brennan's response, he talks about how, it was an investigator that recovered it, but he doesn't name the name, right? They're going to have to get their story straight. They're going to have to figure it out, who it was. And that's where I think that is going to be very interesting to see if that does indeed end up being Ken Berkowitz.
Because
very insightful.
They don't want an evidentiary hearing because they don't want all these people to have to get up on the stand and swear to tell the truth. And they don't want to have to put Latley on the stand and McLaughlin on the stand. And I'm like, these two better find lawyers quick, because this is like, Latley, not only did he, in my opinion, potentially suborn perjury, but he perpetrated a fraud on the court by even putting that video up and asking if it was a fair and accurate representation. And then Yuri on cross is like, well, yeah, I mean, it is a fair, it is like, it depicts everything that like happened, but it's like a mirror. It's like when you look in a mirror, it's like, flipped.
Yeah. And what are we going to get from Judge Cannoni? She's going to accuse the defense of making speeches about all of this. Well, let's make a speech.
And then he also says in his opposition that Karen Reed is unable to demonstrate any prejudice. You mean like an entire first ducking trial? Could that be considered prejudice, that she went through an entire trial already? I mean, if there was no trial yet, right? You could say, all right, well, it's late, but there's no prejudice because she hasn't been convicted yet. Or you're going to say there's no prejudice because she was already tried. Yeah, she was already tried, and we had all this stuff, and we're just giving it to you now after the trial's over. But she wasn't prejudiced because she wasn't convicted. Like, how do you even make that argument in good faith?
Yeah.
Because both Brian Higgins and Brian Albert were thoroughly cross-examined at trial with their phone calls. And we gave them 167 pages of card swipe records from the Canton PD on the 22nd, 29th. Mr. Higgins was cross-examined. And then they even have the gall to say that the Canton, I think they were talking about Jutras. They say that the Canton or the town, like keeper of all the evidence, I'd have to find it, was on the stand, and you could have cross-examined him about all that stuff that we didn't know existed because we didn't give it to you yet.
Because we didn't give it to you.
How would they know to cross-examine him on any of the stuff that didn't exist?
Yeah.
It's just, it's such a laughable argument.
Yeah. Yeah.
And then there's the whole Jennifer McCabe issue, turning over the impeachment evidence. And then she's got inconsistent statements, dropping off the daughter,
disclosing that. That's one that is that's pretty black letter. Impeachment evidence is Brady, and inconsistent statements are impeachment evidence. And part of what the Commonwealth hides behind in this case is they hide from the magnitude of all of the cumulative effect of everything that they have done that is dishonest, that is deceptive, that's concealing the truth of what happened. And so they go in and pick things apart, piece by piece. Oh, well, it's not material, what Jennifer McCabe did, because it wasn't really that big of a statement. Well, no, but it's kind of pretty important in the context of she's sitting in the driveway of the investigating officer who is part of the circle of corruption that ties in with what's happening in the Sallyport and the theory, the case that is being fabricated against Karen Reed in order to protect the fellow officer who, according to the text messages, nothing was ever going to come down on him. They decided that from day one.
He's
So
Boston cop too.
yeah, you don't get to just piece. You don't get to just take this little piece out and be like, oh, well, so what? She said she was picking the girl up instead of dropping the girl off. It's immaterial. No, the problem is not in the context of everything and all of the dishonesty in this case and how it fits in specifically what she is being dishonest about. It's pretty important.
And that was precipitated by text messages between Jen McCabe and her sister the day before, where her sister said, "We'll find out more tomorrow."
Yes.
Don't text about it. We'll find out more tomorrow. What's tomorrow? Oh, all of a sudden she's in Lank's driveway. And by the way, why was she prepped for her testimony by Tully? In Tully's report, he doesn't say, I met with Jennifer McCabe and also Adam Lally was there and Laura McLaughlin was. I met with Jennifer and Matt McCabe. She said she went with her daughter, Allie. She goes to meet Tully and and Tully says she asked to listen to her 911 call. So I let her do that. And then we gave them copies of their grand jury testimony, her and Matt. And then they wanted to see the dash cam footage of Matt and Jen. So I showed them that too. And then that's May 10th. He doesn't transcribe it until the 29th. She's already testified by that time. They don't turn it over to the defense until June 4th. And then Brennan has the audacity to make the argument of, well, he didn't call Jennifer McCabe back to the stand. So, no big whoop. He had the opportunity to.
When was Matt McCabe on the dash cam video?
Somebody said,
dash cam video?
I never saw him.
He wasn't supposed to be there. He wasn't supposed to be there, right? He stayed home.
Yeah. Somebody said that he came to the scene after Karen was brought back to the scene. Karen was taken away in the ambulance and sectioned. I saw somewhere that he maybe showed up around that time and they may have caught him on dash cam video then, but I don't remember.
Didn't mention any of that.
Testimony.
Didn't mention any of that. Awkward.
Yeah.
Awkward.
Yeah. It's like, rarely do I get speechless, but as like the longer that this goes on, the more speechless I get because I have secondhand embarrassment even reading this because it hurts my soul. It hurts my soul to read this.
Well, we have spent many, many years in this system. And the thing about being a lawyer, I mean, there's obviously lots of different kinds of lawyers, as we are seeing in the context of this particular case. But those of us who go into it in good faith, we have to have some kind of belief in the legitimacy of the institution, that it is, we have to have a little bit of an idealistic perspective of the justice system, that it is going to function correctly, that people are going to take their roles seriously, that they're going to do it, they're going to operate with integrity, and that the whole purpose is to try to get justice when justice is going to be a function of the truth, of developing the truth, and demonstrating it to people who are going to have the power to decide what's right, what the law requires in this particular situation. And so that's why it's so hard dealing with cases like this, cases like Delphi, is just because the lack of integrity, it's so embarrassing. It makes me so ashamed to be part of this system. And that's not the kind of lawyer that I ever was. It's not the kind of lawyer that I want to be. It's not the kind of lawyers that should be in the system. And to the extent that they're out there doing this, they shouldn't be. And we should have no tolerance for it. And we should have a lot more options for how the hell do we fix this? Right. How do we fix this? But I mean, Judge Cannoni alone, and how obviously uneven-handed she is in her treatment of the parties. And what's the recourse? They can't do anything about it. They can't do anything about it. I just saw something. Somebody brought up to me an excellent point, and I went and checked because I'm like, this is a little bit concerning. The habeas briefing, the response that was filed. Now, the parties, the respondents to the petition, are Norfolk County Superior Court. Okay, the Superior Court. And the Massachusetts Attorney General. That's who the petition is directed towards. The person who filed the response to the petition is a special attorney general. And that special attorney general is, oh gosh, let me get his name right here.
Ipsy Dixit.
Uh-huh.
And his name
It's
is
Caleb
Ipsy Dixit.
Schillinger, a special assistant attorney general who works at the Norfolk District Attorney's Office.
He
He's
did.
an
He was their
assistant
appellate lawyer for the
Norfolk
SEC appeal.
ADA.
He argued
Why
it.
is he representing the interests of the court? And how is that not a problem when it comes to the partiality of that court? Now, the Norfolk County District Attorney is advancing and defending the interests of the court, and we're supposed to believe that the court is impartial with respect to this party. Now, how does this not create something of an appearance of impropriety?
Listen, the appearances of impropriety go all the way back to the motion to recuse, which I went over again last week. We read the decision for fun where she didn't recuse herself. There was so many appearances of impropriety between, the judge maybe knowing some of these parties. That's where the Auntie Bev came from when Sean McCabe, Matt McCabe's brother, wrote a text or a message to Turtle Boy saying, when Turtle Boy asked him, like, do you have an in to the judge? And he said, who, Auntie Bev? Whose beach house do you think we're going to bury your corpse under? That's where that came from. She was presented with those messages. She was presented with a Venmo transaction from between Ryan Nagel and Julie Nagel that said for Frank and Beverly, but it was spelled Beverley. And she said, I don't know them, and that's not how I spell my name. However, her husband's name happens to be Frank. There were so many things that gave her an opportunity to say, look, I don't know these people. I don't know. I don't know what this is, but it gives the appearance of impropriety. And for those reasons, I'm going to step back. I'm recusing myself. Peace out. She didn't do it.
No.
She had a lot of opportunities to do it. There was a motion to dismiss or to a motion to disqualify District Attorney Michael Morrissey for his egregious misconduct and that hostage video that he did. That was denied. There was a motion to dismiss the indictments based on all the shenanigans that happened during the grand jury and Proctor not, being forthright about his relationships with people and Lank knowing the Alberts and getting them out of trouble for decades. Like the tentacles of this case go so deep. It's like the roots of this family tree are so freaking twisted that you need like a Brandy Churchwell chart to even start to figure it out.
Yeah. And so it's so disillusioning because as an attorney, we're supposed to be able to explain this and we're supposed to be able to justify this. And this is unjustifiable. What am I supposed to tell people? How am I supposed to explain this situation to my audience as if this is like okay and normal? You can't do that. You can't justify the unjustifiable, not if you're going to be, try to be the person that's dealing with this with some kind of integrity. And so it sucks to be in a position where you have to be saying, this is messed up and this is not how it's supposed to work. And this is unjust and this is unfair. And this is not how the system is supposed to be. And yet, strangely, case after case after case that keeps coming up. And here we are dealing with the same thing over and over and over again.
Right. And then anyone who speaks out about it is personally taxed, doxed. They've been trying to shut me up for over a year. I started covering this case in January of 2024. That's when I went off Twitter. I'm like, what do I need this for? Like, I don't need these people attacking me. Like, no, I have no interest in this. And so they've had a concerted effort. They've got a team of people that are out there specifically trying to shut people up. Boozy Beauty has just entered like YouTube. She was on TikTok for a long time. She's local. She's in the county. I saw a video that she dropped today where she has said that she's been followed. It's real. Like it's real what they're doing to people. To have like Yuri Buchanan out there knocking on doors of women who sent Facebook Messenger messages to Jennifer McCabe a year ago to try and have them like prosecuted. Like the intimidation factor is off
Yeah.
the charts. The fact that Brian Albert and Colin Albert came and sat and stared the jury down during closing arguments. Like there was, I don't know if you saw the juror interview. There was a juror who did an interview with Aidan Carney who said that he found that to be intimidating.
Yeah.
Like it's just nothing like this. I mean, I guess we can't even say nothing like this happens in real life because you saw it in Delphi. You were there firsthand. We didn't see it. You saw it like in living color.
Yeah.
What is the proper remedy? And so what is the proper remedy for this? This egregious governmental misconduct. What do you think the proper remedy is? I mean, there's a difference between what we think the proper remedy is and what's really going to actually happen here. I think dismissal. I don't think that you can say there's no prejudice when she's already been tried once. And had she had it, the burden is not on her to show that this evidence would be exculpatory, right?
Yeah.
The burden is on them to show that it wouldn't be exculpatory.
Yeah.
So it's just awfully coincidental that all of a sudden the new video that just came out shows her car backing into the Sallyport and has the rear tail light blurred out. Like it's awfully coincidental that all the video in this case has that taillight blurred out. And now they have clarified the videos, he says. So now they have altered the videos again. And so what do they think that's going to show?
I can imagine what it's going to show because we saw that in Delphi too. Once they get up to their shenanigans with the videos, they can show, whatever they want you to see.
What do you think the proper remedy is here? Because they could exclude the video, but the defense is going to want the video in to show how corrupt they are, right?
No, I mean, I think best case scenario as far as what they're actually going to get, they might get a spoliation instruction. I think that would be Bev trying to display herself as like magnanimous and being fair and tossing them a bone. And from a strategic standpoint, that's how you somewhat insulate that type of decision from further review, is you give the defense a small bone. Here, you can have a spoliation instruction, and you can instruct the jury that is. Yeah,
explain what that is.
Yeah, so a spoliation instruction is it's basically when evidence goes missing or is destroyed, the jury can specifically be instructed that they should infer that the reason why that particular piece of evidence isn't available is because it would be against the interests of the party who had control of it. So in this case, the video, the Commonwealth had possession of the metadata, the logs, all of that stuff that would have shown this information. It would be an instruction that tells the jury, you can infer that all of that is bad for the Commonwealth, and that's why you're not getting to see any of it. Well, is it helpful? Sure. Is it an adequate remedy? Absolutely not. And the reason why it's not an adequate remedy is because the problem here goes so much deeper than just, is this fair for Karen Read and is she going to get a fair trial? It goes to the integrity of the court. It goes to the integrity of the Norfolk County District Attorney's Office, and it goes to the integrity of the trial process, of why we have criminal trials in the first place and what they're even supposed to accomplish. So, no, I don't see anything short of dismissal, with prejudice being even close to adequate from a fairness, from a justice standpoint. But we both know that's not going to happen.
Yeah. And when she denies it, which we have a feeling that she probably will, even though in like the real world, anywhere else, like if we were in New Mexico,
Judge Summer would have had enough.
It would have been dismissed in open court the second they put that video on the screen. She would have been like, all right, everybody out, send the jury out. What are you doing here? What the fuck is going on? Okay, case dismissed. There's some question about whether they would have the right to appeal that prior to, the trial happening. I don't know that they've got a right to appeal that. I think they can take it up to a one justice panel to see if they'll hear it. I don't even know if an interlocutory appeal is even possible on a motion to dismiss like this. And do you have any thoughts on that?
I don't know specific to Massachusetts law. It's so unlikely because the discretion is vast when it comes to
Right.
what's an appropriate sanction.
Mhm.
It would depend on exactly how she wrote the ruling and what the specific grounds were that she found. A lot of this stuff, that the devil is always in the details. But just the overall 10,000-foot view is that this is an extremely discretionary decision, and to get interlocutory review on pretty much any decision, you have to show, it's kind of like the standard for a preliminary injunction. You have to show that, like, hey, anybody can look at this and it doesn't pass the eye test. We're probably going to win this. So you really need to take it up and deal with it now, so that we don't go through all of this expense and everything unnecessarily. It has to be really obvious that there's a problem. And when there's that much discretion, that's almost impossible to show.
Well, she's the gatekeeper, as she loves to say. And
Mhm.
I can just imagine her just writing denied, scribbling on the bottom denied, signing her name and the date, and that's it.
Yeah.
But here's the problem. In order for her to deny the motion, she's got to take all of the facts alleged by the defense as truth, right?
Mhm.
So if she's saying that all of this stuff is true, what is she going to, you can't reason that. If all of this stuff is true, how can you say there's no prejudice? How can you, I
Yeah.
guess she could weasel her way out of it, like she
Oh,
did with the
no.
motion to recuse and the
I
other
mean,
motions.
what she can do, I don't know to what extent she'd be able to do it without having an evidentiary hearing, which of course, she doesn't
Right.
want, the Commonwealth doesn't want, but she can always fall back on, when she gets to find facts, then she's the ultimate arbiter of who and what is credible. And judges who are very canny, judges who are very practiced at insulating their decisions from judicial review, they know that. They know that they can simply find whatever facts are going to be convenient for the outcome that they want to reach, and base that determination on, I believe this person and I don't believe that person. So even though we have a gazillion reasons for any reasonable person to disbelieve what, for example, Trooper Buchanan would have to say, or what even Mr. Lally, who's the one who's implicated in all of this, in the suborning of perjury and so forth, we're going to find him more credible than we are.
And Jennifer McCabe is very honest and truthful, because she told us she was. She told
Yes,
us
she
she
did. That's
was.
right. She
I'm
did
very
many
honest and
times.
truthful. I tell the truth.
You know who else insisted she never told a lie? Amber Heard. Amber Heard was very insistent that she was extremely truthful.
And again, but the finding of fact is supposed to be left up to the jury, right? So
Mhm.
my head is so blown away by this. Do you think she's going to grant an evidentiary hearing?
I mean, I think she's going to do everything she can to not,
Right.
if there is a way that she can wiggle around it. And like you said, even if we took all of the facts that the defendant has alleged and assumed that they were all true, here is why they aren't going to be, entitled to any kind of relief. Here's why the Commonwealth didn't really do anything wrong.
They didn't know. His excuse is, we didn't know they existed. We didn't know.
Yeah.
The knowledge of all of the MSP and all the CanPD is imputed to the prosecutor's
But
office,
only when
right?
they want it to be. See, only when the fellow officer rule is beneficial to the police
Right. The
does that work.
loophole.
But when it comes time for accountability,
Right.
suddenly nobody knows anything. Isn't it funny how that works?
Yeah, I don't know nothing about nothing. And this is the thank you, Alessi's suitcase of receipts. I love how people change their usernames to match the trial. And some of these usernames are like a major competition happening. This is a great one. Alessi's suitcase of
I
receipts.
like it.
I apologize in advance if this has already been asked, but doesn't Judge Bev have to allow an evidentiary hearing? And what would happen if she denied both? I think we just answered that. What would happen? She's the gatekeeper. She's got wide judicial discretion. Here's another little wrinkle. Well, first let's talk about, what do you think's going to happen with Alan Jackson? Do you think she's going to, what do you think she's going to do about that whole issue? Because really that motion was to exclude ARCA, right?
Yeah.
And then they brought in this whole ethical concern, and you better bring your. It was kind of like a you better bring your lawyer with you next week. And luckily, there's Bobby Alessi stepping up to represent the team. Like you don't get it any better when you have an attorney on your team that can represent you, because he wasn't there for the first trial.
Yeah.
What do you think? What, if anything, do you think the judge is going to do with Mr. Jackson? And what do you think she should do?
Yeah, I think she definitely wants to. She wants to revoke his pro hac vice status. I don't think there's any question about that. I think she's been dying to do that pretty much, from day one. But I think there is a pretty significant problem if she does that. It's a very high risk move. Mr. Alessi, he's just masterful. He is such a good lawyer. And it's like the one upside is very selfish of me of this case going forward to retrial is I cannot wait to see that man go to war in trial. It's going to be amazing. It's going to be such a learning experience. But the problem is that when it comes to the Sixth Amendment right to counsel, the choice of counsel, this is a very strong issue on appeal because it's not a situation where you typically have to go in and you don't have to show prejudice. This isn't like ineffective assistance where you got to be like, oh, my attorney made a mistake and now I got to show like how significant this mistake was and why it probably affected the outcome and stuff like that. Choice of counsel is much, much easier to establish. This is the attorney I wanted. You didn't let me have that attorney and your reasoning wasn't justified. So it's very, very high risk when somebody gets to hire their own private attorney, and that's the one that they want to disqualify that attorney to get that client out, or to get that attorney out of the case. And so Mr. Alessi, I think, did a fantastic job of arguing that and bringing up a lot of the case law that's very, very favorable, that it has to be serious, egregious misconduct. It needs to be repeated. It needs to be intentional. I mean, that was a very important point. I think the knowing
the binder.
I mean,
we
there's
talk about
so
the trial
many
binder, and he had a binder for the judge. Like,
yeah,
it was tabbed.
Yeah, binder was amazing. Well, it's funny how so many of these issues like are coming up over and over again in different contexts, because we had the same situation in Delphi, right? And she tried to kick the defense lawyers off the case. They had to go all the way up to the Supreme Court. The Supreme Court reinstated them, but then the prosecuting attorney comes at them with a contempt citation and tries to, get them basically criminally prosecuted for contempt. And so that's really what the whole issue turned on is there a knowing violation? And it's a tough standard to meet. And in this particular context, again, where they're talking about something completely different than what happened with ARCA after the trial. We're talking about the development of ARCA's opinions, the conduct of their reconstruction, the scope of the work that they did, what they reviewed, how they did it. All of that, there's no dispute, nothing in the record that suggests that the defense had any involvement in that whatsoever. They had no opportunity to put their finger on the scale at all when it came to those decisions. And that's what the whole ARCA motion was about the substance of what they were testifying to. So to be making representations that are truthful about the fact that the defense did not pay for any of that, the defense didn't hire them to do any of that. All that happened is that after the fact, long after ARCA testifies, they get the bill in the mail out of the blue. And what do? Yeah, they pay it, because when you need that witness to come back for a retrial, what you don't do is get in a pissing match with them about their bill.
Yeah.
You keep your critical expert very, very happy for the next trial, and then disclosed all of it to the Commonwealth in a timely fashion. Now it's available for them to use in the next trial. So it's just such a nothing burger. So I think it's a huge problem for her to remove Alan Jackson from the case. I don't think she's going to do it. What I would expect would be something very similar to what Judge Gold did when she decided the contempt issue, which is that she took the opportunity to verbally abuse and chastise the defense lawyer. She called them sloppy and negligent and all of these terrible things on the record, but ultimately had to find that there was not a knowing violation of the protective order. And so I think that's a good roadmap for Judge Bev to get her personal vindication and to vent her spleen against Mr. Jackson.
Should we call Judge? You think she'll be calling Judge Gull? Hey, Gull, how'd you handle this? All right, good, thanks.
Well, I mean, they're already adopting the secrecy, you know, the impounding more and more of the documents, the things that we're not allowed to see. Why are we not allowed to see a sidebar transcript from a previous trial? Why are we not allowed to see this?
I don't know. Why do they not have to state the grounds for their objections? Why is it like a catch-all? Like, okay, let me guess. Mr. Lally, do you want to object, Mr. Lally? Okay. Do you want to object? You sure you don't want to object? Sure. Because then it preserves all objections for appeal. What is that? In New York, when you object, if you don't state your grounds, they sit there and wait for you.
Yeah.
To tell them why you're objecting. And it's not enough to say that every lawyer should know why you're objecting and every judge should know. There are some lawyers who genuinely will stand up and object because what the witness is about to say hurts their case. And that is exactly what Lally did. That doesn't make it objectionable.
Mm-hmm. Oh, 100%. 100%.
Let's go to I think that she's been looking for a reason. I think she's been looking for a reason to get rid of him. I think it would be quickly appealed. I'm sure they're already drafting appellate papers in the event that she does decide to do that. Could she fine him $1,000 and call it good? That's what she should do, if that. But I don't even think that I don't even think that there was any mens rea. I don't think there was anything intentional about what he said. And I think she was most pissed about what he allegedly said to her at sidebar, because she said, I read that transcript and you said that you didn't hire them. I think that was the exact word, hire. It wasn't even retain, it was hire. And that's the truth. They didn't hire them. Yeah. They paid them after the fact.
After the fact.
And let me tell you something, from hiring experts on the regular, a $24,000 bill for 2 witnesses to fly into Boston from wherever they were, like Pittsburgh, twice, to put them up twice. There's no way that there was a line item for trial testimony, because trial testimony alone is probably $15,000 per guy per day.
Sure.
So that is very obviously, they were hanging their hat on trial prep. That means that Mr. Jackson prepped them. No, it means
this is not a term of art. This is not a term of art. No expert is going to show up on a nationally televised trial not having reviewed anything that they did, not being prepared to know what they're going to be asked about. I mean, really, they're going to just do nothing and come in cold on the stand and wing it when the entire world is going to see them, and that's going to be representative of their work and their organization? Of course not. A professional witness will prepare. They will review their materials. They'll refamiliarize themselves with the work that they did. So they're acting like this prep is some kind of term of art that necessarily means you sat down with the lawyer and did it. But no, it's not at all. And I mean, I don't know how it is in Massachusetts. In Washington, I subpoena a witness. I have to pay that witness fees. I have to pay for them to be able to get to the court. And there's like some kind of per diem and stuff like that you have to pay them for. Does that mean I'm hiring the witness? Did I hire that witness to show up? No, I did not. No, you did not. It's the cost of the subpoena. They're not obligated to incur the expense of complying with a subpoena. That's on the parties. So none of this is unusual. None of this is strange. I mean, the context is unusual because how many of us have the federal government investigating our case for us? Right. That's a little bit unusual. But as far as just the sequence of events and how that went, it's not really extraordinary to me.
And I think that he made such a big deal about it and he was so bombastic about it because he knew this motion was coming and he knew what was going to be in it. And so he felt like he had, And he didn't put any of that stuff in writing. None of that stuff was in his papers. None of the stuff that he got up there when he said, I don't care if Arca testifies. I don't care if Arca testifies. I don't care that let
Then
him
why
testify.
did you
I
file
don't
the
care.
motion?
Right.
Why are we even here? Why are we here if you don't care if they testify? That's when you say, Your Honor, I would withdraw my motion, and my apologies for wasting the court's time.
Yeah, withdraw the motion. Withdraw the motion. Again, same thing with Betterow. They want to admit Betterow pro hac vice. Oh, by the way, Alessi is pro bono. Did you know that? He came in
Yes, I
pro
did.
bono.
I did.
As are like Jackson Yannetti. Nobody's getting paid anymore. They're like, we're not taking our money. We never expect to collect our $5 million. Like all the money that people donate to the defense fund is going to experts and appellate briefs and all of that. You know how expensive appellate printing is, right? I don't have any opposition to Betterow joining the team. I just have some thoughts that I'd like to share with you. And then he gets up and he gives his thoughts, which again are not in writing. It's not an opposition. And yet he says all of this BS about accusing also Mark Betterow of ethical violations, that he's been sharing confidential information all along with the defense because he represents Aidan Carney. So blatantly also he has no shame in getting up there and blatantly accusing other attorneys of ethical misconduct, which is really like, you got to really cross over into like the dark side to have no shame in doing that.
Yeah.
And then he makes all of these allegations. And then at the end, she says, well, Mr. Yannetti, I'm going to have to consider everything that he just said. And we're like, it wasn't on paper. It's not even an opposition. What are you talking? There's no evidence of it.
It's not
all
sworn.
of these allegations have no evidence to back them up. How do you do that? Let's go to some questions because there's a million and I don't want to keep you here all night. Adriana, thank you. Oh, she's so excited and she's been following you since you started your channel. Thank you. The Goodmans are here. Oh, they sent me, I think, a Venmo and they said, we don't know if we can come. Thank you so much, Goodmans, also for the Venmo. And Adriana is back and says, Andrea and her notes, haha. How many pads did you use during the Johnny Depp trial?
Oh God, 20 some. I still have those under my desk right here. I have my whole collection of all my different notepads.
When you do your memoir, that's going to be like a thing. You can auction those pads off, maybe. Oh, that's a good idea.
I don't know. They're kind of dear to me.
Sheep Girl says Bev and Judge Gull are and leave their own. Thank you for your super chat. Hanky Can't Do That by Bob Alessi. So excited to see two of my brilliant favorites on one screen. Thank you, Melanie and Andrea. Missed your face, Andrea. Yeah, we all missed you. I was like, when are you coming back? I know you're having a great time out there in the wilderness and the wild, and it's beautiful and all, but I really, really, really need you to talk to me about this. Mr. Monk's understudy, Andrea, I'm worried Hank is going to copy the Delphi prosecutor's strategy of using Richard Allen's words against him and edit them however he wants.
Well, this has been like a back and forth of who's copying who, because they've already done that. They already started that with the I hit him. I hit him. I hit him. I hit him. We've already gone through the editing and the revisionism. In Delphi, we had Steve Mullen get on the stand and tell us all kinds of things that Richard Allen said in the interview, that when we then watched the interview, we saw that none of those things were said. He did not say that he drove the route that Mr. Mullen claimed that he drove to get to the trail. He did not say he took that route. He did not say he parked where Mr. Mullen told us he said that he parked. He did not say that he was wearing the clothes that Mr. Mullen told us that he was wearing. So this was another like exercise in gaslighting where, you're supposed to listen to what they said and not, your own ears and your own eyes, what's actually unfolding in front of you. So we already have that happening with Karen Reed.
We do. And it's so sad. And the people of Massachusetts, or so many of them here, have been dealing with this for decades, and they know the corruption is there. And I think some people just have such a hard time believing that there is corruption. And living on Long Island, I know firsthand, Suffolk County, we had our share. Love Bobby Alessi's Bobby Alessi's butter is here and loves Andrea's brilliance. Thank you for your super chat. Because Flinch would love your thoughts on the Commonwealth providing a certificate of compliance after previously claiming that it didn't exist, and Bev denying compelling its discovery, stating that it didn't exist. Does this certificate of compliance satisfy their discovery? They did it last time too. They filed one and then they kept turning stuff over.
I mean, there's been no consequences for it not being complete after they've certified that it's complete. So why would they make sure that it's complete now before they file their certification? I'm not going to be surprised at all if we get into this retrial and stuff is continuing to trickle in
Magically appearing
while the trial is underway.
Oh yeah,
there's been no consequences for it. So.
Right. It's like when children do not have ramifications for their behavior, they continue to misbehave. And that's what it's like. It's like we're dealing with a bunch of children. Thank you for that super chat. Bobby Alessi's Butter. In my opinion, Bevy will fight for April 1st so she can be at her KP just by July 1st. A lot of people think that too. Thanks for your super chat. Allie's here. Andrea, have you put any thoughts into DJ under mass common law right to right to request a sufficiency of the evidence hearing after hung jury, relying on not guilty at counts 1 and 3. It's been angering me that the defense didn't raise this issue.
Yeah. So one of the other issues that comes up in a double jeopardy context is that you can't be tried if the state's evidence was legally insufficient to convict you of the crime after trial. And so that's why if you appeal a conviction and, for one reason or another, you get a determination that there was insufficient evidence, a retrial is barred. Your case is thrown out. It's like one of the kind of holy grails in appellate work. You don't get it very often, though, because the standard is so extremely generous. It bends over backwards. It basically says, if you take all of the evidence and you look at it all in the light that is most favorable to the prosecution, and you assume that all the credibility issues are resolved in their favor and so forth, then in that situation, could the jury have relied on that to find all of the elements beyond a reasonable doubt? And so it's only typically really viable in a situation where you have an element of the crime that gets completely unaddressed, a situation where just there's a mistake, there's a piece of evidence that maybe they need to present that for whatever reason they forgot to do it. Oftentimes it's a legal argument. It's based off of, they went into trial assuming that the law required them to prove this, but actually the law requires them to prove this other, and they didn't present any evidence on that. So those are the types of ways that you can often get a conviction for insufficient evidence, but it's very rare. So, the reason why I think they didn't raise it is because it's just not viable under the standard. It wasn't going to be granted, because looking at everything in the light most favorable to the Commonwealth means you put your common sense, take your brain out of your head, go ahead and put it in your desk, and you decide that, Trooper Buchanan was telling the truth, that the videos all showed what the Commonwealth said that they showed, that Karen said, I hit him, that, John died from a motor vehicle collision. His injuries they weren't typical motor vehicle collision injuries, but certainly could have been that Trooper Paul's reconstruction was credible, and that we buy that as an explanation for how all of this went. So that's why the standard, I think, doesn't work in this particular case, is because it really is a take your brain out and just assume that everything that the Commonwealth said is true. And if everything the Commonwealth said is true, is she guilty? Well, yeah, it's because you have to use your brain to look at what the Commonwealth presented and see that it's absolute nonsense and it's ridiculous, and it doesn't pass the eye test, it doesn't pass the smell test. That's how you get to Karen Reed is not guilty. So yeah, I think if they could have raised the insufficiency of the evidence, absolutely agree. From a legal standpoint, that's another way to get to double jeopardy. But I just don't think it was going to meet that. I don't think it was going to meet that legal standard. It's made for the Commonwealth to win.
Allie, have you and Bob given any thought to coming to Las Vegas? That's my question for you,
Yes.
and I'll give you back your 20 if you answer that question. Kim, I love Labradors, thanking us. Thank you so much for your 20. I appreciate you. Bobby Alessi's Butter, can defense argue in open court the issue of Commonwealth motions without affidavits? They've done that before, and they actually won a motion on that when Elizabeth Little said it's facially insufficient because Mr. Brennan did not attach an affidavit, and they did win that motion. I forget which one it was. But yeah, you're not supposed to do it that way. But apparently in Massachusetts, I don't know, there's no rules. Here,
Yeah.
you must file an affidavit of someone with knowledge to the things that that are in your motion, because your motion is not sworn. The affidavit is sworn. It's the upside down world. Mama, she is here. I'm so mad to be late, but so very stoked for this. Love you too. Loves both of us. I love you too. The biased juror. What's tough is Liza Little writing, we never paid ARCA in their response to the Commonwealth's request to exclude ARCA in February. I think it was truly a mistake, and she had put prior to testimony, it'd be fine. Yeah, there was some language in a motion.
It was February 16th, I think, was the motion. And I don't think it said never. I think it said something like that, ARCA wasn't paid for by the defense or something like that. If it had said never, that would be tough. But now we're still getting into an issue of the knowledgeable, because if we're going to hold, how are we going to hold Alan Jackson responsible for, what Ms. Little is writing in the brief? You need to take these things kind of specifically. And if Ms. Little is writing something that's untrue, should she have known? Did she have access to the information about the payment and so forth? This may sound like it's being nitpicky or over technical or whatever, but it's the requirement to find that somebody is in contempt, that somebody's violated an order. You have to show they did it on purpose, that they knew that they were doing, and not that it was accidental, not that it was inadvertent, not that it was, well, I was maybe a little bit sloppy with my language, because again, here's the context of what we were talking about. We were talking about ARCA developing their opinions and performing their reconstruction. We weren't talking about just the fact that they showed up for trial and then after the fact needed to be compensated for their travel and their appearance and so forth. But I agree that I think if there's anything for Judge Bev to hang her hat on to try to sanction the defense, it is going to be that statement in the motion.
Yeah, that I think that as well. But also, remember Proctor's testimony about his search warrants and, Scrivener's error, and he just kept copying the same paper, and it was like a scratch and sniff, and like Brennan writing his name as Breenan and then attaching an affidavit to one motion without changing like the caption of it. So it's really attached to a different motion, but it says, like, come on, it's like Cat Randall's head is blown off. Your head popped off. Thank you for the super chat. CPU Mod 1. Hey, is it fair that the feds hired ARCA but charged Karen when state should have paid? I may be wrong. Can you please clarify? But charge Karen. The feds hired ARCA and they paid for the reconstruction to be done. They paid for them to do the work of the reconstruction. But for the expenses related to the testimony, that is fair to charge Karen's team for that, because they did come in and testify for her. And in fact, the feds said, yeah, you can pay that bill, even though they were still under contract. So yeah, they didn't pay for the reconstruction, and they also did not pay for the testimony. That was not a line item, because you can bet that if it was, Brennan would have made he would have put a pin in that in his argument, and he would have made that the crux of his argument, I think. Right?
Good point.
Prep. Sergeant Edward is here. Sergeant Buchanan, can you point yourself out with laser pointer? Points at Guy Cross. No idea who that is. Yeah. Thank you, Janelle, for loving us. Thank you for your super chat. Predictions. What will the judge actually do? I think we already answered that one. Thank you, Karen. The other Karen, Emily Morgan. Andrea's been one of the most kind and intelligent lawyers on YouTube. Discovered her during the Deb case. Of course, it does not strain credulity to believe you two are the best. Aw, thanks, Emily Morgan. That's so sweet. Love you a latte. Thanks, Jeannie Lynn. Andrea, that was a perfect Bev. Mr. Jackson says,
Mr. Jackson.
Next to Leslie. There's a man PS'd out in the snow. That's my Jennifer McCabe. Hanky
That's a
can do
very
that.
good Jennifer McCabe. That was uncanny. In fact, I might have nightmares.
Sorry, we'll have to do something funny to get out of this. Hanky can do that by Baba Leslie. How can a judge order metadata and then turn around and deny it?
Mm-hmm.
Well, I don't know that she ever ordered. Well, there was a court order for metadata, but they're just saying, well, we just don't have it. So you can't order something that we don't have, right?
Yeah.
Alex, thanks for tuning in from Canada. Holy cow, I just finished watching Robert Barnes Sunday on YouTube and Rumble, and voila, here are my two favorite women to go. Oh, thank you so much. We're happy to entertain you on a Sunday night. Laguna Beach gal. I wish I was in Laguna Beach right now. Remember when on TBAB didn't allow photos of Katie McLaughlin in the jacuzzi with Caitlin Albert without metadata, and yet videos of the murder weapon, taillight, and vehicle is accepted without metadata. Cuckoo.
Good memory. Good memory. I didn't remember that one, but you're absolutely right.
Thank you, Kazadi, for your. We need the tow truck driver to testify in trial 2.0. You know, there's a lot of speculation about why they didn't call the tow truck driver, and you know, you never call a witness if you don't know what he's going to say. And so, you know, you don't know who might have got to him in the meantime to be like, dude, you get up on that stand and you say this, that, and the other, and you know, you might have to watch out for your whole family. Like you don't know what's going on, and so if they couldn't reach him and he wasn't willing.
Canton PD and ISP and Boston Police, they're not going to call you for any tows anymore. You're not going to be impounding any contracts anymore. Yeah.
There was a day where I fell into like a whole rabbit hole of the tow truck contracts in Massachusetts, and it was deep. The tow truck, it's deep. Like, yeah, you're right. There are certain contracts, they're hard to get. It's kind of like garbage contracts, you know, if you know, you know. Listen, what are the chances that the only two cameras with a clear view of the passenger side tail are the only two cameras that produced unusable footage, no footage, but all of the other cameras worked fine? Yeah.
Yeah.
Thanks, Lisa. Hank said, oh, we gave you 90 photos taken by crime scene services of the broken taillight, but he conveniently didn't mention when they were taken. Well, we know when they were taken, February 1st.
Yeah.
Because that's when, I forget who it was that came with the camera to the Sallyport to take the photos of the vehicle, but it was definitely February 1st or 2nd. Thank you, Grace Base. Go TJSL. Just took my last test for my LLM. Never thought I'd be listening to a law podcast after. Nice work.
Congratulations. That's a huge accomplishment.
And good luck. Good luck. It was amazing. I was never had any interest in getting my LLM. I was not all that tech stuff. Just like Heidi Cakes. Can you imagine what Ed Wallace would say if you told him there's no need to investigate crime scene because of snow? Oh, I did. He came on my show once with Duty Ron and he talked about exactly what is supposed to be done. There are strainers for snow. You're supposed to set up a tent. He has a whole thing. I'll try and link that below if I can find that show. But I have Duty Ron and Ed on the thumbnail, and he was outraged. He was outraged.
Yeah. Oh, I can imagine he would be. I mean, it was ridiculous. It makes them all look bad. It's one of those things like when, you know, you have the lawyer that makes all the other lawyers look bad. This cop makes all these cops look bad.
Yep. Thank you, Sarah Boone's Left Kidney, for the super chat. Flummoxed Alessi. I imagine AJ, David Yannetti, and Alessi screaming into the void every time Brennan opens another files, another dropping. I don't know how they keep their cool in court. I don't know. I saw Alessi yelling at him one day. It looked like wicked psyched. There are standards for a prosecutor for a reason, right? They are held to higher ethical standards. But it seems like maybe, you know, if you're special district attorney, you don't have to abide by them. Off topic, did Gull deny the motion to preserve evidence? Can that be appealed before they destroy everything?
I mean, I assume it would be on the same time frame as the rest of the appeal, and so unless they got some type of emergency stay, that's a pretty iffy one.
Thank you for your super chat. I'm more of a Alessi. Commonwealth with Bez blessing says physics does not apply to the human body. Yeah, I know. I know. Hank's fishing expedition. Do you think the trial will actually happen? I don't think it will, but if it does, it definitely will not be April 1st. Yeah, I think it will. I think they're never going to drop the charges at this point. They are so far deep into this. Do you think?
Yeah. Oh, yeah. The sunk cost is what's driving this case at this point, and they're too heavily invested in it. They can't back down at this point. I do think it's a closer question of is this going to actually go on April 1st? And I mean, I tend to agree that yes, if there is any way that Judge Bev can get it to go on April 1st, she's gonna do it. She's gonna push it forward, even though it doesn't have to be. There's plenty of justification to push it out. There's plenty of interpretations of the speedy trial rule that would allow her to do that, if nothing else, just based on the federal appeal that's pending, the writ. But also just motions in general. If motions take time and you want an evidentiary hearing, you can have that, you can do that, and that's a justification for extending the deadline to go forward with a speedy trial. So
if she allows it,
but she doesn't want to. I mean, I hate to be cynical, but I think there's probably some truth to what that previous comment said about how, she doesn't want her summer interfered with. She's got her way that she likes to do things and her way that she likes to organize her schedule. And she doesn't want this to interfere with that.
And remember last year, it started around the same time. Like, Laura Thompson, how does a video become a paper file? Are we printing it one frame at a time? I'm confused by that as well. Was the thumb drive in a paper file? I don't know. Lally's totally sandbagging Hank. Thank you, VK. So I've been thinking about that. I've been thinking that for a while. He's sitting there. He's dejected. He's like water boy, and now he's a witness. And now he could be in some serious ethical dilemmas, let's just say. So he's in hot water. So I started calling him Hot Water Boy. And then people are like, you can't. He's not hot. I'm like, no, he's in hot water. He's in hot water. He's a hot water boy. And as a side note, I just saw Adam Sandler earlier on the Oscars, which we're up against right now, but maybe people are multitasking on two devices. I just want to get back and see Demi Moore collect her Oscar because did you see that movie, The Substance?
I haven't seen it. No.
Oh my God, so good. How can it wasn't he on medical leave at the time of the accident? Yeah, he was supposed to be, but he
was still at the CPD, wasn't he? Chit-chatting with Higgins and hanging out in the Sallyport.
Yeah, that's what this Bobby Alessi's linguistic prowess says, that they're going to blame it on the dead guy. Thanks for your super chat. Nationally, defense needed to make sure the jury knows the DNA swabs from John's shirt were soaking wet. No doubt DNA. Yeah, well, also there were 2 male unknown contributors to the blood, the red-brown stains on his jeans. So, can we talk about that? Because they ruled out Proctor and Buchanan, but, they couldn't get the people in the house to give up their DNA because, rule whatever that is for rule 17, third-party discovery. They were never going to get that. Bob says, what value does an affidavit from Hank Brennan hold? No, it's like toilet paper. The lack of an affidavit from Adam Lally speaks volumes. No, all 3 of them signed that affidavit. It was like, my name is Hank Brennan. My name is Adam Lally. My name is Laura McLaughlin. And then they had 3 more paragraphs about the charges and the mistrial. And then it was like, we say that our understanding of everything in this motion is maybe accurate, sort of, kind of, okay.
Pretty much. Like, we're pretty sure it's pretty close.
I've never seen an affidavit signed by 3 attorneys. One affidavit. Yeah. I don't know. I guess anything goes. Thank you, Bob, for the super chat. Beck's evil. Wait, when did he vomit in his boxers? Did anyone say he was sick at the bar? Nope. Where could he have gotten sick? Inside his pants? He may have, like you were saying, had a bloody nose. If he was sitting down, let's just say, and he vomited from a head injury, because that happens. It does. He vomited into the front of his boxers. So yes, that is true. Thank you, Victoria, for your super chat. Thank you, Kat Randall, for your super chat. Bobby Alessi's linguistic prowess. Yes, it is very disheartening that our legal system, is corrupt. How do we fix it? I wish I knew. Yeah, you know how we fix it? You're watching. You're watching. That's the first step. People need to pay attention. Don't look the other way. Pay attention. Vote.
Vote and speak up, demand accountability. It's tough in a situation where you have, political appointees, serving in a lot of these roles, when you have protected civil servants serving in a lot of these roles. But those rules are created by people that are accountable to the people. And so you just have to apply the pressure where you can and where you have the opportunity to influence the course of action that your government takes. So it's not easy. The system is not made. The system is not made to be easily changeable and to be easily accountable.
Yeah. And but you got to pay attention, and that's the great thing about YouTube is that mainstream media is not going to talk about it the way we talk about it. They're not going to spend 2 hours explaining this to tens of thousands of people at a time. Mainstream media is dead, and that's why every commentator out there is starting their own YouTube channel. Which, by the way, Vinny Politan will be on my show tomorrow morning at 10. So as soon as I hit end on this, it's going to redirect you there so you can hit your notification bell because that's going to be a good one. I think Vinny is turning the corner on this one. I think he's seeing the light. Glow, it says, I'm sorry, both judges are female. Why are you sorry about that? I don't
Well,
think
because
that
they're
has
awful, but I guarantee, there's
anything
no
to do.
women judges have no monopoly on being
They
awful.
You said you saw the juror interview, so that speaks to the overall level of corruption in Massachusetts. Brian, thank you, Bobby Alessi. Byron Albert went to Erica Walsh's workplace yesterday. Erica is a strong and vocal supporter of Karen. I did not know that. Suze, and I don't know who that is, but thank you for pointing that out. That could be witness intimidation. No, maybe not. Selective prosecution. Each one of Canoni's size hurts my soul, says nay. Albert says, I'm waiting for a moment like the Brian Steele and Ashley Merchant movement in RICO case with Bill, where he ended up recusing himself. Maybe. Does anyone find it strange? Yeah. I mean, yeah, from your mouth to God's ears, maybe.
Yeah.
Does anyone find it strange that they sit the O'Keefe family so they can stare at Karen Reed? Yeah. In the Penny McGee trial, her family was behind her. I know. I think they should make a motion to flip that around, in my opinion. But Penny McGee was also a bench trial. Maybe that's the difference. I don't know that they have the right to stare the jury down. I think that's quite odd and intimidating. And I think you're right. Thanks for pointing that out. Will they be able to mention the first trial by name in this trial? No, they can't even mention the first trial at all, right? Can't imagine anyone in Massachusetts.
Interesting. Isn't that going to be interesting, though, if I was thinking about this, if the Commonwealth does in fact want to get into, we're going to impeach ARCA with this $23,000 bill and what it was for and so forth, that's necessarily going to be communicating to the jury that we already did this and we didn't convince a jury already that they should do what we're asking you to do. Right. Like, it seems like a very risky strategy, a very high risk that the jury would not draw the conclusion from that the Commonwealth would want them to. So fine, have your impeachment evidence. Go ahead and argue ARC is biased because the defense paid for them after the fact to be able to show up at the first trial that you couldn't meet your burden on.
The prior proceeding, like they had to refer to the federal grand jury, the prior proceeding until somebody said, oh, the feds, you mean the feds? Thank you for your super chat. Exactly. We ruled on and noted on ruled late. Thank you, DS. How can Brennan get away with outright lies? Says Deja Vu trial too. Seems like they're trying to call him out on it, but it's up to the judge. We just walked in together into that courtroom opening day, priceless. No, I feel to arrange it. Thanks on top. Good idea. And the theme from Rocky playing, right? Parachutes and pirouettes. Please explain how Spanky got away with lying to the court when he said he got the info from the FBI, not the defense. Well, because he got up there and he, didn't really correct the record, but, he said he had to fix the chronology and none of it was in writing. So,
none of it's sworn, none of it's under oath anyway.
Right. Thank you. Andrea, I love your touch of gray. Please don't color it.
Well, I am a every silver lining kind of girl. So.
Yeah, I know it happens. It happens. Victor, if Bev yeets AJ, can the defense ask for continuation? Well, I think they would appeal it and that would stay the trial. Yeah.
Well, and I think they would have a pretty legitimate justification too at that point, just in terms of preparation, because like they've pointed out, they have an allocation of the workload for the defense. And so if you're going to now just, get rid of a third of the trial team, they're going to have a problem filling that gap. And it's not reasonable to expect them to prepare that in less than 4 weeks. So now, is she going to be reasonable about that? Who knows? But it's just that again, just the more you pile on with this type of issue, it's harder and harder to justify that in the Court of Appeals.
Agreed. Meatball Marcy, won't the chain of custody report the retired officer D. Campietro is currently working on be inadmissible? Who knows at this point?
wasn't made contemporaneously. So it's going to be a reconstruction. Is that going to be enough? Well, I guess we'll see what Judge Bev thinks.
It seems ridiculous to me when she said, you can't expect them to manufacture evidence, and now they're manufacturing the evidence.
Now they're manufacturing it. So I'm not allowed to expect anything unless, she wants me to, I guess.
This retired guy is going to remember everything he did and when, going back 3 years. Come on. Kaza, what's your opinion on Judge Bev allowing attorney Mark Betterow on the Free Karen Reed team? I mean, she's got no real reason to deny it. I've never seen one denied before. Yeah. But, all of these concerns that Brennan had that she's allegedly going to take into consideration, even though there was no evidence of any of them being true. Mm-hmm. I don't know what we're going to have to see on that. I think she's got to let him in. But again, we're in the upside down.
He needs to at least present an affidavit or something like that if he's going to legitimately oppose it, which he insisted he wasn't doing. So,
right, like he's not opposing ARCA. He doesn't care, but he didn't withdraw his motion. Mm-hmm. Are Bev's phone records available for FOIA? I think I don't know. I don't know. I don't know if
the judicial records, I think, arguably would be. If it's related to her judicial function, it should be a public record. But anything that's personal, wouldn't
give it a try and let us know. Did you get them?
Yeah, the worst case scenario is they say no.
Thank you for your super chat. Thanks, Misty. Darlene, how much of her temper tantrum was because Brennan said you've been duped in front of a worldwide audience? I don't know what it was about, really. I thought something else happened. I thought there's no way she could be shaken over what just happened. Like, that's just, you don't get shook over something like that. I don't know. Can the defense object when Brennan gives his thoughts? If so, why the heck aren't they? It's not in front of a jury. I mean, the stuff that already happened. Thanks, Amber, for your super chat. Go tell him to, I don't know what that says.
Bumba.
I don't know what that is.
I don't either.
Thanks, Diaz. Terry, brother counsel is saying if you're going to habeas this for the 2 charges, no, the entire thing. All charges were part of the mistrial, so habeas the entire thing. All charges. Thoughts?
So they're getting at kind of different things here because there wouldn't be a double jeopardy basis to throw out the charge that the jury, the count 2, that the jury acknowledged they didn't reach any kind of agreement on that. They started off split one way. They continued to poll, but they never decided that they were going to acquit her. It was count 1 and count 3 that they decided that they were going to acquit her. So from a double jeopardy standpoint, those are really the only ones that they have an argument that she can't be retried on. With respect, though, to the manifest necessity for a mistrial, that is interesting. That's not a bad argument because the idea would be that that jeopardy attached to the jury, once they're sworn in a case to decide the case. And so if she didn't know, or if she had an obligation to conduct an inquiry before she was entitled to declare a mistrial, then the whole problem is the declaration of mistrial. And I think this is a good point, that the declaration of the mistrial affects all 3 charges. It doesn't necessarily just affect the ones that the jury has come back after the fact and said that they acquitted on. So yeah, that's a good argument.
I'm also going to say that if you ask 5 lawyers for their opinion, you're going to get 5 different answers. So, every lawyer's got a different strategy and different reasons for doing the things that they do. And, it's really easy to Monday morning quarterback, but, I don't know. I think, you could get a million different opinions. And I think Andrea's opinion is good too.
I think part of the issue with that too, though, is they do want to be consistent with the recourse that they're asking for. Right. And they also want to be reasonable with what they're asking for. It's much easier to ask for dismissal of the charge that you have the evidence that the jury, was like, we acquitted her. We we have a very good argument that, at least from a fairness standpoint, she shouldn't be retried on this. It's harder to make that argument on the charge that the jury did not reach a verdict on. So some of that can be strategic. In terms of legally, would the argument be available? Yeah, potentially. But could you reasonably make a decision that, we're less likely to win if we ask for too much, and that might be a bridge too far for us to ask for? That's definitely something that appellate attorneys, and frankly trial attorneys too, you have to think about that stuff all the time.
And this way, it's more consistent with the appellate proceedings in the state court. So to now bring up a new issue, I don't know how that would sort of muddy the waters or throw a wrench into things. I don't know. That's your area. What's Karen's best chance for appeal, assuming the worst, says the other Karen? I think that we got to wait and see what happens. I think if she disqualifies Alan Jackson, that's probably the quickest thing, but I don't think she's going to get convicted. So do you have an opinion on that?
No, I don't think she's going to be convicted.
Yeah. Thanks, Goodmans, for gifting a membership. Alessi, Spanks the Commonwealth. Thank you both. Thank you for thank you for your super chat. Nick Starro is here. Thank you so much. Good morning. It's morning. It's morning where Nick is. Oh, we're into the night. Thank you so much for tuning in. Homegrown Alligator watching from Australia. Looking forward to can't stand the double standards. Thank you, Free Karen Reed. Thank you so much for your super chat. Proctor's hard time in the big house. I want the defense to get an expert to describe investigation steps and chain of evidence and why they're crucial, and destroy everything if not used. I don't know that the judge would allow that type of a procedural expert in this trial. I don't know. A lot of people have brought that up, and I just don't know the answer to it.
Yeah.
Great point. Thanks for your super chat. Magnolia Gypsy, ARCA under federal protective order. Defense gets bill after trial. Fed said pay it. So feds don't think defense violated the federal protective order. So why does Bev care? It's not her order. I think she thinks that it has to do with candor to the court. And I think that's what her problem is that she thinks that they lied to her. And that's why she's pissed.
That's why, yeah, exactly.
Lauren Boborin, April Fool's Day is the perfect day to start. Marcello, honestly, Andrea, I was a little bit disappointed that you went to the Chilean Patagonia instead of the Patagonia of Argentina. But,
you know what? This is my second time to Chile now. It's my second time to Chile and Patagonia. I keep finding places that I need to go back to. I have yet to make it to Argentina. However, I will give you some assurance that now that I have discovered the Valle Cochimo in northern Patagonia, you can actually trek all the way through the valley and get to Argentina. It takes, like, from what I've heard, somewhere in the 4 to 5, maybe 6 day ballpark. But you basically ultimately end up in Bariloche, Argentina, which is like the northern end of Argentinian Patagonia. That would give me the opportunity to then, rent a car, maybe go down, see some of the places in Argentina I've wanted to go to. I want to go to El Chaltén. I want to go to El Calafate. I would love to go to Ushuaia. So it's on my list.
Do you speak Spanish?
Todo un poco.
No, just well enough to get by.
Yeah, no, I could function like a disabled elementary schooler is approximately my level of Spanish.
Yeah, thanks so much, Lex. We have covered most of this stuff. Thank you, Kim. Oop. If Andy Bev kicks Jackson out, can he still represent her on the federal level? Yeah.
Yes.
Yeah, he's been admitted pro hoc in the federal court. So thank you, Wendy Sue Winter, for that. Amanda is here. So glad to be catching us. Thank you so much, Free Henry from Detroit. Thank you, Amanda. Desert Quill can't express how much I'm loving this. You guys have heartened me with this beautiful law nerdy deep dive. Oh, thank you for your super chat. The video is a flippy book now.
Yes.
True balls, pirouette.
Well, it is kind of a caricature of a case anyway, so that would be
Jason
fitting.
for the Venmo, who is telling us that it is Dr. Seuss's birthday today, which really is quite appropriate, right? I do not like them, Sam. I do not like green eggs and ham. You will not find them in a house. The guy never came in the house. The guy never was with a mouse. Lamassous, can the defense ask for all the footage from the news crew that was at 34 Fairview the night of January 29th when the CERT team was there? I don't see why they couldn't make a request for that. I mean,
yeah, they could ask.
The prosecution is asking for all of that other news footage for Karen's interviews and stuff. I mean, I would think could be fair game. Good point, Suze. Phil, Does the USSC ever discuss ongoing trials over lunch before they are approached with an appeal? Because it's interesting. I don't know. I've never been a fly on the wall in the Supreme Court, but it's interesting. Would like to ask the jurors who came up with the term distractors. Yes, that's a great point. Thank you, Wicked Psyched. Look at Andrea Glow and talking about Chile. Fun, says DJ.
It's wonderful. I can't recommend it enough. It's such a great place.
Thank you, Carolyn, for your Venmo. She loves us. The world is watching. Thank you so very much. Any final thoughts before you wrap? Because I know, we've been 2 hours here already. We've got a lot of good content in here. You guys are going to have to go watch this again because there was so much information. Sherilyn, thank you for the cash up so much. Any final thoughts?
Yeah, it's just a lot, and I know it's so frustrating for everybody to be in this situation after already having gone through this the first time, and I felt like there was a pretty clear consensus from most of us who were watching about what the outcome of it really was supposed to be. If you understand reasonable doubt and the state's burden of proof and so forth, it's just very difficult to reach a conclusion that the Commonwealth met that. But I am, as I said, every silver lining kind of girl. I do tend to look on the bright side of things, and I have chosen, and I continue to see this retrial as a real opportunity. I think that it's very likely that this team, especially just the way that these shenanigans have unfolded, and now the mistake that the Commonwealth has made of making this very personal. You've now gone after these attorneys personally, and that's upping the stakes. That's upping the stakes quite a bit, and that's giving them a whole new motivation to go in and really kick ass in this. So this is an opportunity because they have the Commonwealth already boxed in by virtue of the previous trial. And they have had now, another year to go in and flesh out their case, to build up some of the arguments that maybe they would have liked to have followed up on, but didn't have the opportunity for. We don't know what they've been doing behind the scenes. I would love to see, for example, okay, you weren't allowed to go and get any Albert DNA. Well, you know what? There's no reasonable expectation of privacy in people's trash at the curb. And the police use that one all the time. The trash paper to go and get the DNA. I seriously doubt they did anything like that, but my God, that would be so badass if they did. That would be pretty epic. But again, just these little pieces that can unravel that we're seeing with the video, the opportunity that they've had to pull on that thread. The other like big detail that I remember thinking at the time, there's potential opportunity here. Is the reconstruction of the tail light, right? And not just that one particular piece that's missing and being able to highlight that, but one of the questions that I had going into the trial was there any leftover plastic? Did they use all of the plastic, to reconstruct this headlight? Just a possible way that this would have gone down. If the CERT team initially found the 4 pieces of plastic taillight and that's all they found, it doesn't necessarily mean that those 4 plastic pieces of taillight were necessarily the ones that came from Karen. You wouldn't need anything. You just need some plastic taillight, because then it all goes into a big pile at the CPD where there's no chain of custody and nothing is sorted out, and you get to sort of stick whatever one
swap them out
want. You get to basically do it however you want. So really deep diving into that CERT search and that reconstruction of that tail light, and particularly the coincidence of those missing pieces. The problem with just the mechanics of how are you finding all of this stuff on the street when the street has been plowed multiple times now, and those kinds of details. They've had so much more time to think about all of this and to really refine their strategy. So I am optimistic the second time around that they're going to have a better case. They're going to have a stronger case. They have certainly added to their firepower on the defense team with Mr.
Oh yeah, it's an
Alessi.
army now.
I am crossing my fingers. I am praying for whoever is in the position to make this happen. Please make Mr. Alessi be the one to cross-examine Jennifer McCabe. He would be absolutely perfect for it because he is so detail oriented. He is so methodical. He's so familiar with everything. And she's not going to outsmart him. She's not going to be able to wiggle her way around him in the questioning. So they just have a lot going for them the second time around. And so I'm very, very optimistic that not only is Karen not going to be acquitted or not going to be convicted of these charges, but that the trial process is going to vindicate her. And in many ways, that is an advantage relative to, a dismissal in some ways is a little bit of a loss because you don't get that opportunity. And the opposing parties always get to go out, oh, well, it was just procedural and it was for this other stuff. It doesn't really mean that she wasn't guilty. It was because the Commonwealth, messed up or whatever. She gets the opportunity to go to trial and tear that case apart the way that it should be. That's vindication.
And try to get her name back and her reputation back and her all these things that they've taken from her.
And that is the upside. That's the bright side out of the necessity of this second process.
Another advantage that they have is the benefit of that juror interview. So they really need to know what to hammer home on now and what confused them and what crazy things they believed and didn't believe. And there was some crazy wacky stuff. And we're just like, what? Like, what do you mean you thought that this person? What do you mean you thought Lucky Loughran was not credible? Like, that blows my mind. I thought he was one of the most, him and I thought that the officer from Dighton Barrows were the most credible witnesses in the trial.
Yeah.
Now, I know that you're my soul sister because you had a Grateful Dead reference and a Monty Python reference in the same sentence. You said, I'm a silver lining girl who always looks at the bright side of life. So those of you who know, and you heard it too, I know you did. Laura Miller, thanks for the Venmo, says, can the defense get any videos from previous cases from the Sallyport to prove it's not always inverted? Yes, I'm sure they're probably working on that. If we're thinking of it, they are. Thank you, Michelle, for gifting 5 memberships. Phoebe, I absolutely think they should get more than an hour to close. I thought that was a ridiculously short amount of time for closings. How much time did they get in Delphi to close?
As I recall, they were each given an hour and a half, and that was, or wait, was it? God, now I'd have to check my notes. They didn't use their full allotment, either of them. And my understanding was that she had asked them, for their input on it. It wasn't a unilateral handing down, this is how much time you're going to have. But it wasn't super long. Maybe it was like 3 hours and they went to something along those lines.
Definitely wasn't an hour. Like an hour was
not
way
an
too
hour.
short for this trial.
An hour is very short. And especially for a case that's got a lot of technical detail like this case, it's just not. And with a judge who doesn't apparently seem all that friendly to demonstrative exhibits, if you can draw something and show the jury to be able to put the pieces together so you don't have to try to spell it out in your words, that can save you a lot of time as well. But if the judge isn't going to let you do that, then it takes time to make your point.
Yeah, I think some PowerPoint slides would be really beneficial in this case. Really beneficial, because I think it really helps me when we're watching trials. And I think a lot of people think visually, and I think that that's a great idea. Edward says, confirming that every cop only ever found touching pieces, I think, is big. That's true too. And also the glass on the bumper did not match the cocktail glass. Things that really need to be pointed out and hammered home. And again, I blame that on the short closings. I don't think that anybody could have tied up that case that was 10 weeks long in 1 hour. K-Wag says, Andrew, did you know there was another party at the McAlberts before Taillight appeared? No one saw any pieces at that time either.
I did not know that.
Thank you. Nurse Kimberly from Kansas. It's 2 terrific lawyers in one show. Thank you so very much. I think that about wraps us up for tonight. Thanks, you guys, for coming. Thank you, Andrea, so much for coming tonight. This was so much fun. I hope we can do this again soon.
Oh, we have to. I'm so, like I said, I'm really honored to be here. And thank you so much for inviting me on. I was a latecomer to this case, and you are like the expert. You are the pro. You were like, everything about it. So I really look up to you and your knowledge and your experience here. And I really appreciate everything you've done with this case.
Oh, well, I'm so glad. The more the merrier, as far as I'm concerned. I wish everybody would talk about it. But, in the beginning, I was screaming into a closet because I was getting
Mhm.
attacked left and right. And a lot of people didn't want to touch. I'm not saying that you didn't want to touch it, but a lot of people didn't want to touch it, still don't want to touch it. In fact, I saw Joel from STS the other day talking to somebody. He's like, I am never, ever, ever going to come and Karen Reed again. And
Mhm.
that was the one time I was on STS was on Karen Reed. So found that
Mhm.
interesting. And he did say there's only 2 women in my life who scare me. My mother and my wife, and now Melanie Little is the 3rd one. So that was also very funny, Marcello. We're just gonna get out of here. What would happen if the witnesses that already testified decide to plead the 5th now? Isn't that right waived for them already? Thoughts? I don't even
Um,
because they've
I
already
mean,
testified and there's prior testimony?
it would come down to, yeah, it would come down to whether they would be in jeopardy. And so if they've already testified, they already have something on record, it would be hard to see how repeating that testimony would put them in jeopardy.
Right.
So I guess the implication would be they would be changing their testimony, in which case, it's impeachable. I don't see it as a really particularly viable option. The 5th is not a broad right that people have. You don't get to just generally say, I'm not going to testify. It's very question by question and specific. And it does have to be a situation where your answer would put you in jeopardy. And so if you're already on record having answered the question, it's hard to see how that standard would be met.
Correct. Agreed. All right. Let's quickly say goodbye. Can you hang up backstage for a minute so we can talk? All right.
Absolutely.
Thank you everyone for coming. We love you so much. When I hit end on this stream, it's going to redirect you to tomorrow morning stream where I will be talking to Vinnie Politan about the Karen Reed case. So you're going to want to hit your notification for that. Please just smash the like button on your way out. Feel free to share out the stream and, do all the things that YouTube likes, respectfully comment, and just, stay cool, stay kind, stay classy. I know you guys could do it. I know you can. Peace. We'll see you soon. Tomorrow morning, in fact. Good night, everyone.